Item 1.
May I please your lordship, my lord?
Yes.
The present petition is from the guarantor, my lord.
Guarantor.
My lord. And the she is ready to, my lord, the total amount is pending against me, my lord, 16,55,609 rupees, my lord, 63 5, my lord. I am ready to deposit, my lord, 5 lakhs, my lord. And the rest of the will be deposited in the repayment, my lord.
Will be deposited in
5 lakhs.
You will deposit 5 lakhs.
6
Out of?
My lord.
Out of 16 lakhs.
16 lakhs. My lord, within a week, within a one month, my lord, I will deposit the amount.
What is happening now?
Now the bank is initiated a proceeding against me, my lord. I am ready to deposit that amount.
You deposit 5 lakhs today.
My lord, within 1 month.
No.
Within a week.
We are not bankers. Court is not a banker. Court is. Any of us have signed your loan document as witness? No. So we cannot alter the terms. Pacta sunt servanda. Abide by your contract.
Today is not possible, my lord. I will unable to contact my client, my lord. Within a week, my lord, I will deposit, my lord.
You will deposit 6 lakhs.
5 lakhs.
No, 6. 1/3 it will be. Issue emergent notice.
My lord, I am the guarantor.
There is no difference between guarantor is the most pampered data.
My lord, my
pampered property. Any standard book on law of banking like Mukherjee, Penal, they say that broadly. Yes, take note. Issue emergent notice.
To accept the notice, my lord, on behalf of
Issue emergent notice. Learned panel, senior panel counsel is requested to accept notice for respondents bank. All OPs?
all
OPs. First off, learned counsel for the petitioner brought attention of the court to the application in IA number 2198 of 2026, supported by an affidavit seeking reprieve during the pendency of the petition. First off, he submits that bank is going to take coercive action on a war footing, and if that happens, his client would be put to manifest injustice. First off, he also tells that his client is a scrupulous guarantor, and that he will show his bona fide by remitting a sum of rupees 6 lakh, which would be approximately 1/3 of the outstanding dues, and then within 1 week, and therefore coercive action be halted. First off, there is force in this submission. Although the counsel appearing for panel counsel opposes the same. Next paragraph. Having regard to all the facts and circumstances of the case and justice of the case as well, and also because the bona fide is shown by the petitioner by offering to pay 1/3 of the outstanding amount, come up with it with appropriate that this application be allowed and coercive action of recovery be halted. Anyway, he wants some order because bank wants its money, he wants his fees. Both are there. In the above circumstances, application having been favored, no coercive action shall be taken by the OPs pursuant to impugned notice under section 13(2) of Surface Act 2002, provided that the petitioner pays to the loan account a sum of rupees 6 lakh within a period of 1 week, failing which the bank can take all coercive actions as if there is no interim order. First up, what amount the next installment should comprise will be decided after the bank files its counter.
Under the OTS scheme, I am ready to settle my account under the.
I may be permitted. This is 13 to notice. He has to give reply. There he should give a proposal.
It is also open to the
I have given my reply, my lord. That is
file his additional reply, if any, the subject notice. Okay. Call after 3 weeks.
Item 2.
Next. There is a dispute as to who appears for the parties in
No. It is 4188.
4180.
Yes.
Here for the bank, is for the petition.
Yes, in weekly list, he's saying. But this is a matter where the petition is pending on the behest of the auction purchaser, my lord. The auction has been held against the dead person. My wife died. During that period, they have given the notice and auction has been held. And thereafter, bank has accepted the entire loan outstanding along with the interest of the.
When the auction took place?
It has been auctioned since, my lord.
Kindly tell the date. We'll look at the calendar.
My lord. It has been auctioned since 2024, my lord.
No, we don't go by that.
My lord. Thereafter, they have accepted.
That time month.
They have accepted entire amount with interest from me also. They realized their fault and taken the entire amount from me and along with the interest of the auction purchaser till 2024, my lord.
Now what happened?
Now the auction purchaser come in a it. So I have now prayed for to pass all the orders passed by the bank as
Which
well.
is that WP?
I have given that number.
All along with WP.
My lord, I may be permitted to serve copy on them.
Issue emergent
And
notice. You have made auction purchaser a party.
yes, my lord.
Issue emergent notice to the OPs. First of all, this matter along with the WP number, WPC number. So,
WPC number 9735 of 2025.
right?
It is there, my lord.
Sign,
Yes.
right? Sign. That will be part of your record.
My lord, I have given in certificate also.
Next.
Item 3.
May I please, my lords?
Ask.
My lord, here I am the guarantor, my lord. The husband of the present petitioner had taken a loan, business loan from the OP number 1.
Wife is the guarantor.
Yes, my lord. My lord, fact is that the sanction loan amount was 35,50,000, my lord.
Huh?
35,50,000.
When
The
it
pre-
was?
My lord,
When it was calculated, computed.
present, my lord, at present. At present, in 13 to notice, they have sent me 13 to notice, my lord.
Okay.
My lord, my only prayer is that, my lord,
13 to this is 12th March 2025.
Yes.
1 month short of a year.
yes, that is there. But my lord, after that, they have not issued any 13-4 or any, not taken any course of action against me. But fact is that, my lord, here the loan has been secured. It was an insured loan. My lord, insurance has taken place and insurance has taken the money from my account. 65,000 something else towards the total loan recovery amount. And thereafter, my husband was died, my lord, in the year 2024. And besides that, I have paid regularly 22 monthly installments.
Take notice.
Yes, my lord.
Take emergent notice.
Yes, my lord.
Issue emergent notice. Application will be.
IA is there, my lord.
It will be taken up for consideration after service of.
Yes, my lord.
After service. Next.
Item 4.
Operation number will be 2 weeks. Yeah. Issue emergent notice level in 2 weeks. IA would be taken up for consideration after service of notice. Yes, next.
Item 4.
Whatever the petition, Lordship. Lordship, on repossession matter, on 16/9/25, the bank repossessed the property.
16/9/2025.
And on 20/9/25, the Honorable High Court passed an order to approach the Honorable DRT and dispose of the matter within 3 months. In the meanwhile, Your Lordship, we have filed in DRT. In the meanwhile, 11 dates have been passed and we have not received any kind of relief. And I am neither a loanee nor a guarantor in this case, Lordship.
You are neither loanee nor guarantor.
My brother has taken the loan. And I am out of
Is
my
it ancestral property?
ancestral property.
So the father is alive.
Mother is not alive.
Then brother becomes the karta. A karta can do the alienation, says Yajnavalkya Smriti. Kutumbarthe, Vyavaharike, Apatkale. In these 3 circumstances, which means on Hindu law recognizes, can sell the property, mortgage the property, lease the property, not only of his share, but of the family.
At that time, father was alive. He was the guarantor.
Where have you stated?
Lordship?
He was the guarantor.
Yes, sir, Lordship.
Yes, he was the guarantor as a karta of the family. Where is the case for you?
Lordship, I was not made aware of the any.
Need not be. A karta need not consult you. In Mitakshara says, the karta need not consult the co-partner. Not only that, he goes one step further. Mullah says, karta can take a decision even when one of the co-partners does not agree. Where is case for you?
Lordship, I am out of my own house.
What we can do? What you can show the law. Law is the only language which the court understands. Nothing else.
Lordship,
We will again request the DRT to expedite them.
DRT, Your Lordship.
Well, we'll tell them, if you do not do, we'll take penal action against the presiding officer. Where is that judgment which you had made earlier? By the coordinate bench, Brother Justice Panigrahi?
Yeah, yeah.
Yes, Your Lordship. Page number 19, Your Lordship.
September 20.
Annexure 3.
You take emergent notice. Let us see what the,
I have instruction to appear, my lord.
why presiding officer is not abiding by our request. When a constitutional court makes a request, the other court should treat it as a mandate, said the Supreme Court. Who appears, whether a tribunal is also a party in this petition?
No, Your Lordship. No, tribunal.
Not a party. Learned issue emergent notice, learned panel counsel accepts not appears for the on request appear for the OPs personal. Next, learned counsel for the petitioner complains that though in the earlier round of litigation, a coordinate bench of this court-wide order dated, go to Panigrahi order, 20 September 2025, had requested the tribunal to expedite the hearing of the matter in, is it essay?
Yes.
Yeah.
He was asked to appeal, file a case under.
In which?
He had not appealed then. He had not filed then within 3 months. That was that.
You have not filed it at all.
We have filed, Your Lordship.
When did you?
Later you filed, no?
Within 3 months you have not filed.
Within 3 months, you have filed, Your Lordship.
When did you file? 29 is the date of this order. When you had filed the,
In October itself, Your Lordship, we have
in October.
So
What is
tribunal-
that number?
Yes.
SA 170 of 2025.
SA 170 of 2025.
So the date has been fixed earlier in the month of January 26.
Yes, Your Lordship. And
The date was fixed by the presiding officer in the month of January 2026.
22nd January 26. And after
26.
that, last year it was
22nd January 2026.
How many hearing dates have been?
10
hearing.
10, no, 11.
When is that? Your
Last date it was Bharat Bandh, so
no, next date was on 12th of February. That was the Bharat Bandh probably.
yes.
Next date has not been fixed. That's the only one.
But 10, where 10 would happen? You have filed it in October 2025. You show that. Where is the order sheet? No, it cannot be 10 at all.
It cannot be. You have not filed the order.
Common sense says it cannot be 10 hearing dates.
In the IA, it is only one
You
date.
produce this is recall.
Page 22, Your Lordship.
Have you
Wait.
produced the order sheet? So that
Page 23, Your Lordship.
23.
Yes.
What is that? These are the dates.
22 and 23 years.
4/11. Oh, that is in the main application, no? How can
so many dates, sir.
in case of the details, argument, hearing, how do you see it? Is it of yours?
Yes, sir.
Where is it? So stage of argument has come.
Yes, sir.
Huh?
So the pleadings are complete then.
Yes, sir. On 17/12, it was argued, and page 23, Your Lordship, may kindly see that while further dictating order, the tribunal felt further hearing on IA. We filed an IA.
Yes, IA it is. Further hearing means hearing of IA.
IA.
No further hearing. Hearing of IA.
Yes, sir.
We will request the court to take decision on this IA at the earliest. All right. The petitioner, you are the guarantor.
I'm not.
No, not at all concerned. Petitioner is knocking at the doors of each court with the following prayer. Next paragraph. Learned counsel for the petitioner submits that in the earlier round of litigation in WTC number so and so, a coordinate bench of this court had made certain observations favorable to his client, and accordingly, his client had filed the proceedings in October 2025, semicolon. The proceedings were taken up for consideration in terms of interim application several times, and no order has been passed on the same, though urgency is highlighted before the tribunal, and therefore the tribunal be directed to take a call on the subject application without effecting further adjournments indefinitely. First off, learned panel counsel appearing for the OP bank is agreeable, in all fairness, agreeable with this proposal. First off, next paragraph. The right to speedy justice is one of the facets of Article 21 of the Constitution of India, said the Apex Court several times. First off, when an application is moved seeking interim protection, even CPC 1908 provides for its disposal ideally within 1 month. 1 month. First off, that being the position, we request the presiding officer of the Debt Recovery Tribunal to take a call on the subject application without adjourning the matter any longer. First, all contentions are kept open. First, ordered accordingly, writ petition is disposed of. Courts having next.
Item 5.
Against 4 is the auction sale notice mail.
Auction sale.
Yes, ma'am.
What is the outstanding?
Because the
One thing we want to impress upon the bar, this court is not a super tribunal. It is not a super DRT. Our jurisdiction is limited because of Bafna, Kailasam, all these judgments you have seen. Limited interference. So what is the, and you have to show the bona fide.
yes.
Enormous bona fide you have to show to attract our jurisdiction.
Next 2 is the demand notice.
We're asking you, what is the amount?
Yes, the amount is as per demand notice 29 lakhs some odd million.
As
29 lakhs, 93,000. So it is around
of 30 lakh.
Yes, around 30.
When it was, notice was issued on which day?
That is issued on 19/11/2019.
19. Yes, sir.
That has already been decided, ma'am. Under Annexure 3, your lordship can see that has already been decided. Against on the self-same demand notice, they have issued the auction sale
So
notice.
Debt Recovery Tribunal has disposed of the
Under Annexure
what
3,
was the order?
yes, Annexure 3, your lordship kindly see.
What is the order?
Different deprivations. When a debt recovery tribunal issues a decree, that becomes the debt only. Then reaffirms.
Yes, again they have issued the auction notice.
Yes, they can.
The matter issued matter that amount as per the demand notice has already been decided, matter.
No. But
Decided you are not paid.
did you pay within
I have
30 days?
already, I have deposited 38 lakhs before the DRT matter.
When?
During course of the proceeding in the SA, but that amount has not been taken back by the bank.
Who
And
appears for the bank?
I have instruction to appear. In this case, SA has been disposed of by quashing the sale notice. What I have seen from the record.
SA disposed of quashing the sale notice.
Previous sale notice. And directed to take fresh steps.
You have
By the-
taken also.
We have taken fresh steps.
He says that he has deposited a sum of.
For the DRT, he has to take back that amount and deposit before the bank if he is interested.
Anyway,
Your amount is safe in the hands of the.
No, it is not.
You will direct the DRT to remit that.
No,
money to you.
your lordship may see the order.
Yes.
That has not been done. Your lordship may see this order.
what is that?
I have seen from this record, my lord. I don't know what is the position.
You accept notice.
Yes, my lord.
Ratio emergent.
Your lordship,
Notice,
your lordship may keep it day after tomorrow. I will take entire instruction and it can be disposed of.
Accept notice for
But
the.
tomorrow my date has been fixed.
Tomorrow it can be. I
For
can take
sale,
instruction, my lord.
And
Why
it's for-
tomorrow? Over a phone, you can phone call, you can take information
Well,
and
yeah,
come back. Tomorrow is see, if it is a case of where money is not paid, he has deposited 38 lakh. Right now, we'll direct the DRT to remit that money.
Yes, my lord. Your lordship may direct them. We have no.
You will not cause the sale at all.
but that-
As your lordship direct.
No, you have to say on that. You are a counsel.
Yes, my lord. One passover. One passover.
Pass it. Yes, we call that order. Pass over. Yes.
Item
When he
6.
has already deposited, he should not
No,
tell the
there is a, in
debtor.
the order it has been there, it will be returned to him only.
Let us see.
Right, my lord.
Just ascertain and come back.
Item 6.
May I please, Lord?
Yes.
My lord, here, my lord, reserve price is 99 lakhs rupees.
Huh?
99 lakhs rupees, reserve
Reserve
price.
price.
Yes, my
What
lord.
is the due?
Number 2 lakhs, 2 crores 43 lakhs they have shown.
When it was?
It was, my lord, in the month of January, 8 January 2026.
26.
Yes, my lord.
2 plus
2 crores 48 lakhs.
around 250.
Yes, my lord.
Yes.
And my lord, reserve price they have fixed to 99 lakhs rupees.
Who are you?
I am the my lord Loni.
Loni.
Yes, my lord. And one OA is pending before the London DRT. In the 2017, it was filed.
Yes.
Thereafter, my lord, negotiation was going on. They agreed, and I deposited substance as per that instead I was depositing the money.
How much?
My lord, in the meantime, up to
How much?
60 lakhs he has deposited.
When?
My lord, I have not given the schedule. I have asked over phone only. That I have not mentioned in my petition.
Advocacy.
My lord,
What
this
kind of advocacy?
is a mistake on my
You
side.
don't know what is the money remitted by the borrower to the loan account. This is the loan matter.
That is extremely sorry, my lord. It's a mistake on my side.
All right, 50 lakhs is paid.
Yes, my lord.
Yes, then.
My lord, what I pray, my lord, since there is my lord, DRT is open there, I have to approve to that court. But difficulty was there's a PO said, register said clearly, unless the notice will be sufficient, we can't do anything. Well, it cannot be heard at all. That's why I have to approve this on court. There are a number of grounds are there because before auction, they have to value the property. They have not valued my property. There is valuable property at Guarantor town, around 124 decimals of land, which is around, my lord, 3 gunts, more than 6,000 square feet, my lord. And one more thing is here, my lord, section 8, rule 8 of DRT Security Act, that has not been followed. And also,
All this can be taken up before the DRT.
that is DRT, my lord. My only predicament is here, I could not approve this honorable court. But what time auction has been was held on 13th of this month, 13th February.
13th February.
Yes, my lord.
Now how much money you will deposit?
My lord, if your lordship will direct in 2 installments, at least, my lord, I will deposit 25 lakhs rupees.
225. For when the amount is
My lord,
2.50.
my lord, otherwise, my lord, what my lord will say that I will suggest to my client.
You deposit 1 crore, 50%, because sale is already, auction has happened. Nobody will come forward tomorrow if we interfere in these auctions.
Yes, my lord, that is the
interest
the
of-
law is against me, my lord. I am conscious of the fact.
Yeah.
But what I pray, my lord,
Yeah.
the 1 crore will be a little bit higher. May I pray for?
Yeah, it is less than actually what we should have ordered.
My lord, then man, give me 3 months time, I will arrange the money.
Nothing like that. We
Well,
are
as you
we
lordship-
cannot much tinker with your loan.
Yeah, no, my lord, I bow down, my lord, whatever orders my lord will pass. Because I have to put because the
Auction has
last.
happened on 13th February. 13th February. You will pay 1 crore 50. Cancelled. You are being louder.
Non-participation of the bidders.
Not participated. So auction failed. Now how much money? Now they will.
Yes, my lord. Then, my lord, once this proposal will give, let it be considered.
Now you are before this court.
Yes, my lord. My lord, I
I
have.
will tell them to hold the auction day after tomorrow.
Yes.
It's a public money.
Yes, my lord, that I cannot. But I am repeated, I have gone through that. Everything is against me, my lord.
Yeah.
Only the technicalities and the
Therefore, now if you show bona fide.
Yes, my lord.
After all, bank wants its money.
Yes, my lord.
It's the principal and the interest.
Yes, my lord.
You should not have the principal that you will not pay back the interest. You should not have the, and you have no interest in repaying the principal either.
No, my lord, that.
That is how the conduct of the proceedings will show.
That.
Now tell me, how much, tell us now, how much money you will remit to show your bona fide, so that we can tell them not to hold the auction.
My lord, what they have done, they have fixed 99 lakhs to reserve price. That is the first money they are supposed to take.
That is on merit, so we'll go into the river, we will swim into the river waters, Gangetic water.
My lord, the money which will be given to the bank, but if I will get some bidding time, I can arrange money outside and pay the money.
You take notice and come back with your version. No entry model.
My lord, auction has been held, not held.
That's-
Yes, my lord. Yes, my lord.
Yeah, issue emergent notice, learned senior panel consider on a request for the OP bank. First off, he tells that the auction that was scheduled on 13th February 2026 has not taken place for want of auctioneer, the intending buyers, bidders. First off, in view of that, IA number so and so, hotels into insignificance and accordingly is pulled off.
Well, one anxiety I have, if also will permit me. In the meantime, they would go for auction within a period of 3 weeks or 4 weeks, then I will be in deep trouble.
All right, you make a
I will-
representation.
Yes, my
Not
lord.
with that money, we will direct
Yes, my lord.
back to consider.
Yes, I oblige.
Learned counsel for the petitioner submits that his client is willing to settle the outstanding amount. And in that connection, he intends to move an OTS application, which the bank will consider in accordance with law in terms of RBI guidelines.
Yes, I oblige, my lord.
Amount which is required under the operating.
RBI
Yes,
guidelines.
Yes. That
RBI guidelines.
definitely. Otherwise, he has no case.
With this proposal, the counsel appearing for the bank, though initially opposed, is now agreeing. provided that all contentions are kept open.
Yes, ma'am.
All grounds are kept open.
With permission only. You will submit the proposal within a stipulated time.
Yes,
Also,
Next paragraph. In the above circumstances, this petition is disposed of, giving liberty to the petitioner to make the OTS proposal within 2 weeks. 2 weeks by complying with the necessary requisites. And if it is so moved, the bank shall take a decision thereon in accordance with the RBI guidelines.
Hello, brother.
Within a period of 2 weeks next following, till the end, till then, no coercive action shall be taken against you. Yes, you want to sell the property.
No. I want the issue will be resolved here.
Till that happens, till
For
that
this,
happens, the coercive action shall not be taken.
Hello, brother.
I have taken instruction, my lord.
Yes.
Your lordship has seen page 33. There is a direction to take back the amount of 38 lakhs by the petitioner.
Yes.
And I ascertained from my lord and brother that he take back that amount from DRT also.
You have taken that money.
And yes, I have
Return
taken
that money to the bank.
my lord. If he will deposit by tomorrow, then we will also consider his OTS application. He will, if he will submit the OTS application, it can be settled also. I have taken to that extent also.
Very good bargain it is.
Within a week.
Within 1 week, he says. But money,
Tomorrow is
the money whichever you have taken,
Yes, my lord.
Yes,
Tomorrow is
you deposit tomorrow.
Yes.
All right.
a rest for rest amount, it can be settled, my lord.
Yes, that's what.
Within a week, I deposit within a week.
Within 1 week.
Then they have taken the amount.
When
Now,
the auction is scheduled?
tomorrow is the auction.
Tomorrow.
Yes.
When you took the money back?
My lord, I have back after the order having been passed by
That
the,
is a long time.
that is,
And retain the money in your pocket.
no, my lord.
But where did you keep it? In wife's
Well,
pocket?
again, I have to prepare the draft and deposit before the bank or more. It can
When
be
did you deposit? Where is the bona fide? Appears to be unscrupulous debtor. To him, we will not grant this writ jurisdiction, to borrow the words of Justice Dhawan of the Allahabad High Court. Writ petition is not meant for loafers. This may be a wrong word, but this is what the Allahabad High Court said. It is not. It is meant for scrupulous people. Where is the scrupulousness you are exhibiting? Your client is exhibiting.
My lord, order having been passed on 21/7/2025.
Where so much time was with you. Where did you run away with that money, having taken it back? And where have you stated in your petition that you have withdrawn the money? Show that.
My lord, I have the instruction.
We are asking you.
My lord, I have not stated in my.
Then we will dismiss it with costs. Exemplary costs.
My lord,
You said your money is lying with the tribunal. It's a couple of minutes ago.
Yes.
A couple of seconds ago.
my lord, I have only stated the direction has been given to the petition to return back the.
Next you have not stated.
38
This is like Ashwathamo Hataha Narova Kunjarava. This is like this. Ashwathama is dead. But that Ashwathama is elephant, not that Ashwathama. You have said you have taken, there is an order to take back. You have not disclosed that I have taken back that money. This is sufficient for denying relief.
That is how you have
I'll
to take.
deposit the entire.
That is how
What?
you took effort.
Entire amount when? Today.
So, my lord,
Then don't
By tomorrow.
dismissing.
by tomorrow, my date has been tomorrow. My lord, I'll deposit.
What time auction is what time?
Auction is not survey copy, man. It is. Normally the auction is from 10 to 3:30.
10 to 3:30.
Thereafter,
You hold it after 1 p.m. tomorrow. In the meanwhile, he will credit that money.
Yes, ma'am.
If he does not credit, go for the auction.
Yes, your lordship may pass that order. I have also taken an instruction that for the rest amount, if you will submit an application for OTS, that will be considered liberally.
No, we don't agree with that proposal. Because not scrupulous. Rector. Petitioner, borrower is knocking at the doors of writ court with the following prayer. Next paragraph. Learned counsel for the petitioner vehemently submits that the client had deposited a sum of about rupees 38 lakh in the DRT during the pendency of SA number?
That is SA number.
C6 OA number.
SA number 2.
SA number 20 of 2021. 2021.
Which was on
Which has been since disposed of. First of all. Petition does not,
July 2025. Dispute of
21
21 July.
Applied order date is 21/7/2025, entered by the DRT. First one. The petition very conspicuously does not say anything about the amount deposited by the petitioner has been back by him pursuant to the order. First one. This could have been one singular ground for denying the relief to the petitioner. First off, however, we don't venture to do it because of the fair stand taken up by the bank through its counsel, which is appreciable. First off, the panel counsel submits that if the petitioner deposits entire amount outstanding before 1 p.m. tomorrow, that is 17 February 2026, they would 18 February 2026, they would bank would drop the idea of holding auction of the security property. First of all, with this proposal, the net counsel for the petitioner is agreeable.
My lord, as per the auction notice, the entire outstanding has been stated at 53 lakh.
We do not know that when it happened in others, in the above circumstances, and with the above understanding, petition is disposed of. Okay, next.
Item 7.
Yes, it will be ready. Prepare that for me. Propose it immediately. Yes.
Item 7.
No, ready ಮಾಡ್ಕೊಂಡು ಹಾಕಿ ಆಗಿಂದಾಗ ಗೊತ್ತಾಗಲ್ಲ at least. ಮತ್ತಿಲ್ಲಪ್ಪ ನಾಳೆ ಆಕ್ಷನ್ ಆಗಿ ಹೋಗ್ಬಿಡು. Yes.
The bank is trying to sell out my residence property by committing fraud on document. After section 13(3) and
Serial number
7.
Yes.
After 13(3) and 34 notice, my lord, two properties are against me. I entered an agreement with the bank, arranged a prospective purchaser to sell out one of the properties to.
What is the loan amount?
Loan amount 5 crores, my lord.
When it was borrowed?
Into 22, my lord. 22. Now the outstanding is 5 crores, my lord. Outstanding is 5. The lordship trying to annex 1, the agreement passed between the agreement signed between amongst the prospective purchaser, the bank and the loan, my lord.
Yeah.
I annexed the prospective purchaser. He agreed to sell, purchase one of the properties, my lord, for 2 crores 3 lakhs, my lord. 2 crores 3 lakhs. That agreement was signed on 20th December 2025. Annex 1, my lord. Suppressing that agreement, my lord, bank sold the property on 30th December 25, my lord.
Agreement is dated
20th December 25, my lord. Annex 1. The prospective purchaser agreed to purchase for rupees 2 crore 3 lakhs.
3 lakh.
2 crore 3 lakhs. But the bank sold it on 30th December, my lord, for 1 crore 86 lakhs.
When? What was the time
83.
given under the agreement?
That agreement time.
What was the time given?
Yes.
What were the conditions? Suppose if the conditions have not been.
No, not
applied.
condition violated. Before the time was expired, my lord, the LRC turned to page 15. Page 15 of the writ petition, my lord. Clause 2, subclause 1, my lord. The entire sale consideration, LRC got it, my lord.
The entire sale consideration of rupees 2 crore and 3 lakh.
3 lakhs shall be directly paid to the bank by the purchaser before or at the time of execution of the sale deed through bank demand draft such and such in the name of Punjab National Bank, account number such as the period
On
the
20.
December 26.
26.
Yes, 1 year period.
Yeah. 26.
26.
26.
Yes, 1 year period. 1 year. Clarified is 1 year period, my lord.
Oh, that is 1 year.
1 year period.
Is it true? No.
I'll tell you, is submitting the half truth, well, I'll come to.
But the bank sold the property at 1 crore 83 lakhs at a lesser amount.
Was there any other condition saying to show bona fide so much money should
No,
be
my
paid,
lord.
etc.?
There is no such condition, man. There is no.
Yes.
Bank sold on 30th December for a sum of rupees 1 crore 83 lakhs. Putting me loss to
Sold on
30th December, my lord.
30/12.
30/12/25. 10 days of
Agreement was on 20.
20/12/25. 30/12/25.
25.
Yes.
Thereafter, again, they issued
That purchaser is made a party to this proceeding.
in the
Okay.
yes, agreement, OP3, my lord.
OP3.
OP3.
Yeah.
Agreement was a tripartite agreement.
No. Party to the proceedings.
Proceedings, my lord. OP3, my lord.
OP3.
OP3.
Yeah.
OP3.
Let us see what they will say. Any other ground you have?
They have now, so at the time of sale, 13(3) notice, earlier notice, where the outstanding was 4 crores 89 lakhs, my lord. Now again they are issued a notice to sell the other property, my lord, my residential house. Showing
Without
outside
deducting this money.
without deducting, how much they have not intimated me, my lord. Again they have shown a higher amount.
Counsel is here, na?
Yes,
Let us
counsel
ask.
is here.
Yes, sir.
But the actual fact is that to whom they brought through the tripartite agreement is no other than their own son-in-law.
Yeah.
So this is a related party transaction. First fraud, it is vitiated through fraud, they did not disclose. That
Did you rescind the agreement?
prohibited. Lordship can cancel this tripartite agreement and the auction sale also.
When it was cancelled?
No, Lordship, they have challenged it. They disclosed when the sale certificate was issued, they all were there in the bank. The father-in-law, who is party to the proceeding, he is also assured that I will make good of 18 lakhs because my son-in-law is not paying. And now, Lord, the officer who worked on the good faith, now they are complaining because the other property is under sale. That is nothing to do with this.
1 second. There was an agreement.
There was an agreement.
We are asking you.
Well,
There was an agreement dated 20 December 2025. That had given 1 year period for settling that.
that was mistake because it ought to have been for a 25, December 25 within 88 days. Well, in any stretch of imagination, bank will not give a 1 year time.
We do not.
No, but
Will you interact with the person saying this date is wrongly fixed? And
Yesterday, one of the petition, the father-in-law say that I'll pay 20 lakhs to make good. Yesterday, based on yesterday.
we do not know that. We are asking you because we'll go by law.
Right.
That is what we have been taught under Chitti's contract law, Anson's contract law, Fifoot contract law. They say this Mohri Bibi has gone now. Mohri Bibi versus Dharmo Das Gash 1921, perhaps 1919 or 21 judge 21. 21 judgment of the Privy Council is no longer good. There is an agreement. Fraud is one of the grounds that would vitiate the agreement. Doctrine of coercion, fraud, undue influence, mistake. These are the 4 grounds on which a contract can be rescinded. Did you do that? You have not done that. Then did you inform me? 1 year period is given. That was not the intention of the party. The actual date is this one. Therefore, come and execute the rectified.
They all were there in the office. Orally, I submit nothing to writing.
All they were in the market.
unless you take
All they were in the Katak market.
No.
Can we take cognizance of that?
I do it.
Yes, sir.
only one letter would have been sufficient.
Yes.
So what is challenging the tripartite agreement as well as the sale?
Yes.
Both can be set aside by your lordship. We will return that amount to the purchaser. Let him hand over the physical possession of the property. We'll go for the fresh sale. Let him.
What do you say? He is so fair now.
Yes.
You're challenging that?
Yes, I
Where is
agree.
where is the buyer?
Look, we will go for fresh sale.
And can we set aside buyer this sale without notice to him? He will come with another
He is a
petition.
party to the proceeding.
Is he here?
No.
IGB made a party here. No.
He is made
He's
a
a party
party.
to proceed.
Notice has to go to him. You cannot take a decision on his behalf because your sale has already taken place under 54.
That is the position.
We will issue notice.
No, that's
Without notice, can we do? Issue emergent notice, learned panel counsel Sri so and so accept notice. Volunteers to take notice for
I'm filing my
bank,
colors.
bank, and he has filed wakalat also in the open court leave. That would be part of the record. Full stop. Emergent notice to OP number 3.
3, my lord.
You are for 1 and 2.
I'm for the bank.
Back. Returnable within 2 weeks. First, OP number 3 is have you made any application? Any interim application is made?
Yes, my lord.
Learned counsel appearing for the petitioner draws attention of the court to the application in I number so and so supported by an affidavit seeking a reprieve. First off, regard being had to all the facts and circumstances of the case and the fair stand taken by the counsel appearing for the bank that the entire sale transaction itself may be struck down and property be permitted to be put to public auction for recovery unless the amount is remitted to the
Including the tripartite agreement that is initiated by fraud because related party transaction.
unless you take some action. Why can't you read some contract law? I'm sorry to say this. I have to tell this because
I'm sorry, Millard, since he's challenging that tripartite agreement also.
How can we do it?
can we do that? Can we do that?
I'll file.
And what you say about the date is also not in figure alone. You have put it in the word. It is 1 year. How can you say that it's a mistake?
And if you should have called him back. There is one judgment of Kerala High Court that is made under the provisions of specific relief for rectification of the
Yes,
yes.
There is a provision in
yes.
specific relief act itself. If he does not come, you did not call him also. You never called him also. Going by the present proceeding, you take up a stand. In fact, there is a famous book on this aspect. That is Cheshire, Fifoot and Farmston on law of contract. It's the English law of contract. Much is similar to Indian law of contract also. He has dedicated one chapter for cases of this kind. The next time you just go through.
It is not the malified intention to plant the son-in-law without informing the bank.
Right, but
Who knows all this? Unless you give a notice. Can you assume and keep quiet?
They are not saying no.
No, but can't we
What panel counsel you are? We are sorry. Beyond this, we will not say to you. And the fitness, next one, in the fitness of the things, we are of the considered view that the OP number 3 be restrained from alienating or encumbering the subject property till next date of hearing. There should be some examination for High Court practice. Yes.
Item 8.
Yes, sir.
There was a lot of notes are there. This case arises out of the award of the labor court, Your Lordship.
Award of the Labor Court.
Yes.
2014 matter.
Yes, Your Lordship.
What
And
is
there
this
are
very list itself is long. What the list? Let us see.
There have been 2 occasions, Your Lordship. One is, there are 2 reliefs granted, Your Lordship. One is the re-employment. The other one is paying some compensation. That
Re-employment or reinstatement?
Re-employment.
Re-employment. It's a fresh vincular series.
Yes. And there is an award also for the interim compensation, Your Lordship. That interim compensation amount has been taken up by this Honorable Court. We have already paid that amount, Your Lordship. What I was suggesting to my learned friend, with regard to the other aspect, which we have re-employment, since re-employment is not now possible, 11 persons are fired in the meantime. But the other persons, we can think of some monetary relief, Your Lordship. That I wanted to discuss, if we can discuss, and if Your Lordship also gives me an opportunity, the matter can be under mediation also. I'll talk to my...
2014 matter.
Yes.
People will be laughing at us.
No, not laughing.
11 years. 11 years.
Both of us, we can suggest one amount which will be acceptable to both. The matter can be settled here. It's out of court.
What do you say?
Let him give some offer. I will consult with the workman.
Fair enough, Your Lordship.
You go before the... We will appoint somebody from the bar here. You need not go there also. No, because of
Let him give some reasonable offer.
No.
I may accept that.
No, we ask you to sit under the shadow of a tree in the court campus and put forth your version. You put forth your version, so that the mediator whom we will choose from, whom you will choose from, you may choose. We have nothing. We have nothing now because of that is available because of reinterpretation of section 89 of CPC. Is it? Therefore, you just turn around, see some blossoming faces are there, choose one of them, two of them, whichever way you want, and complete this process. There is a
what I was.
I don't know. In fact, I think it is a Shukraniti. I do not know. The one particular scripture says, Vinashakale samutpanne ardham tejita panditaha. When everything is being lost, one who says part of that is a pandit, wiser man. It applies to both of you. Because
that is what part your
litigation is a lottery. It says
what I will submit, your lordship, only submit. Now it's a matter of 2014. If I
turn around and choose a face. Turn around and choose a face. We are saying, no, we cannot do it without your consultation. Turn around and choose some face, whichever face you want.
Or name anyone.
1 week. Only 1 week we are giving. Next week we are taking up the matter for passing the orders this way or that way.
Your lordship.
Therefore, turn around.
Why I am submitting?
Turn around.
Well, what I am submitting, after if it fails, your lordship, I am free with my own submissions, your lordship.
That's what. That's what. Turn around now. Choose one of the persons from the bar. Choose any one of them. Both of you. Turn around. And you can say the other person who is not here also. Only thing is, one who has already joined the larger world, we cannot call him back.
Mahanti is there.
Take that.
I have a bad reputation of not mediating.
But this will be the starting case for all such things. It will erase all such bad.
Anyway, if other person is taking, because Mr. Mahanti is saying that he is not interested, maybe there are reasons.
No. Mr. Rautrai.
Yes, Mr. Rautrai.
Yes.
Sir,
Help us.
you have to do. We don't say it is a pro bono.
No.
You can charge.
Can I suggest one thing? Mr. Mahanti be there.
Both of you.
Yes. Fine.
Mr. Mahanti, now a burden is reduced. You can't say no.
Fine, your lordship.
Yeah. Both the sides, on the request of this court, stood tall at the bar and have chosen Mr. Mahanti, learned senior advocate and former advocate general,
Yes.
and Mr. Rautrai, learned senior advocate, as a panel of mediators for resolving the disputing question. First up, the management shall remit the fees which the mediators would indicate in their
Your
discussion.
lordship not the side. Do it. Do it. Say, I
Unnecessary. Taken. Because you should not take money from the workmen.
No. Cannot.
That's the reason.
From management also.
Both the sides shall furnish all the case papers and their notes, if any, to the mediators within 3 days. And mediators are requested to accomplish the mediation task within a period of 2 weeks.
2 weeks is better.
Will it be all right?
Yes.
First up, the parties shall fully cooperate
Yes.
with the mediators. Since these mediators are an extended arm of this court, and they will have all such powers. First up, timing and venue shall be indicated by the mediators. First up, this court places on record its profuse appreciation for acceptance of this mediation by the learned senior members of this part. First, registry to share a copy of this order with the parties to the counsel appearing for the parties to the litigation, and with the learned mediators immediately. Call this matter on 17.3. 17.3, all right. For you.
17th, I'll not be there.
But tell whichever date you pull down from the calendar.
16th of March. 16th of March.
16th of March. 16th of March. Ah. Do it immediately. Yes, next.
Item 9.
Yes, sir.
Sir, item 9 may be taken up at 12 noon.
Ah, first, sir. This police CR.
Item 10. Item 10, my lord, on behalf of Mr. Das, my lord, can you prepare next week, taken up next week, my lord?
Item 10.
10, my lord. I will respond to one, my lord.
Had asked us to make a research on that law of penumbra. We did, and we were like very enlightened on
Doctrine
that.
of penumbra.
Yes, Your Lordship. In fact, it has also been applied by by the Supreme Court in the right to privacy case in Puttaswamy's case.
That's one.
In fact, even the American judgment was in the line of right to privacy, and this was also right to privacy, and where it says that
Yes.
even if
Share a copy with him also, so that
we'll give all
along
these
with your
citations.
So which date you want?
Next week.
Next week. Next week already.
Lordship.
Which year? 2024. We'll fix a day. See how many cases are posted on
February.
24. One matter. Post it on 24. Only one matter we have posted that day. Along with that, we will take up this.
Obliged.
At the request of both the sides. At the request of oneself or the respondent. Respondent. Okay.
Item 11 has been adjourned. Item 12. Item 12 on preferred next week, my lord. File rejoinder, my lord. Opposition number 3.
Rather, on the same day.
Item 13. Item 13.
Uh, 13, my lords, I may be pardoned to appear in BC, my lords. Plus, I have sought consent from opposite parties, my lords. It may be posted for hearing some other date, my lords.
Some other day.
My lords, pleadings are complete. It is for hearing, my lords.
Pleadings are complete. First of all, call this matter in the third week of March.
My lords, can it be first week of March? Can I request for first week of March, my lords?
One who seeks adjournment cannot seek a date.
My lords,
Yes.
my lords.
Item 14.
Yes, sir. Ah.
So my learned senior is there. Not let me begin, my lord. And he'll come.
That is your understanding.
Not he'll come. But he'll come to my aid only, my lord, if I fail, my lord.
Yes.
Not should I?
For my non-senior students, that I am raising a very preliminary point.
Yeah, let's just come here. Kindly yield the mic to your friend.
We are appearing today.
All right, you are appearing with this next.
I'm raising the preliminary objection with regard to the maintainability of this writ appeal. Okay. Why I'm saying so? That the district judge, admittedly, the district judge has passed the order. And
Under which act it is?
that against the award was put to execution. The award passed by
Section 34.
yes, section not it is not an award under section 34. It is an award under the National Highway Authority Act. 3G subsection 6.
3G 56.
3G 5.
35.
Yes,
335.
yes, 3G 5. After the award was passed,
After award is passed, it goes to the district collector.
it will go to the for execution. It will go to the land discharge is for execution. And apart that, the lordship can see section 3G, subsection 6.
National Highways Act. NH Act. Then it travels to 226.
My submission before your lordship, Lord. The Lord single judge has exercised the power under Article 227 only. Not under
Therefore, no intra-court appeal.
It is not an order.
What you are saying, we understood.
Yes, ma'am.
What you say, 3G5 or 3G6.
6.
Yeah, 6. Then it goes to 227. Because admitted jurisdiction.
Yes.
Because of that famous judgment, Virajkar versus State of Maharashtra. But once 227, it is not intra-court appeal.
Appeal is maintenance.
Not maintenance.
Intra-court appeal is not maintenance. And apart from that, Lord, once the arbitrator, the award passed by the arbitrator put into execution, Lord, then the order which has been passed by the designated court, Lord, or the civil court, principal civil court, then it is a trapping of the civil court. That is that there is also the decision. That order has been passed by the learned civil court. Because it is not arising out of a suit.
1 second. Yes. You mean to say civil court is a civil court for all practical purposes?
All practical purposes.
Therefore, whatever appeal, etc., is provided in CPC,
yes,
they can avail.
They can.
It's not a persona designated.
It's not a persona designated. It is a court. It is the order passed by the civil court.
Let us read that section.
Yes, ma'am. The lordship can see the section 3G, subsection 6. Subject to the provisions of this act. The provisions of arbitrator.
Our arbitration is one thing.
Yes,
putting the award in execution is another.
That the lordship can see the subsection 7.
The competent authority of the arbitrator will determine the award taking into consideration so and so. Now, why you are saying this is section 386 is an arbitration proceeding? What is your answer?
It's an arbitration proceeding.
85, my lord. The collector and arbitrator has been appointed by the central government. Or arbitrate the matter
and he passes the award.
Yes, he passes the award.
Arbitration comes to an end.
Power conferred on the land acquisition under section 3G1. So power conferred on the section 3G5 with the arbitrator. Or the collector has been appointed as designated as the arbitrator. Each and every district, all over India, they are exercising power.
Correct.
By exercising such a power, 3G6 says, in subject to provisions of this act, means NH Act 1956, the provisions of the arbitration concerns acts have been applicable to the.
So it will be arbitration proceeding.
Yes,
It's an arbitration proceeding.
Number 1. Number 2. Now this is over.
Yes, ma'am.
This that is over now.
Madam, what happened, madam, in this case, particularly subject to minor's permission and
No, my lord, he is for the national. He is for the national highway, my lord.
Yes.
But I'll place before lordship.
The law can be said. Anybody can say that.
On merit of matter, very surely. Here is a case, my lord. Initially, there was a draft notification under section 3A1 for notification of the land.
It is like a preliminary notification under the LA Act. Like section 4. This is 3A. Comparable to section 4 of 1894.
Earlier for intention to accuse.
Yes,
One to he was getting notified. The officers or objections are invited under section 3C of the NH Act. Any person has any grievance, they have to file before the land action objection. Whether in objecting or not objecting, if the land acquisition officer decides the issue under section 3C, pass an order, the matter shall refer to the central government for vesting of subsequent notification under section 3D.
Final notification.
No, that is declaration, no notification.
That is final declaration.
3D is a declaration.
Section 6.
Exactly.
The declaration.
Correct. Our section 6 of 1894 Act.
Exactly.
Let submit my applicant.
No, he wants to clarify. He wants to clarify because I had doubt. No?
Yeah. I am clarifying, trying my best clarify what it can get. After the land has been notified and declared under section 3C2, the land has been vested to the free from all encumbrances and the title and to the central government. Thereby the land virtually the owners have used the right title in interest.
Slowly.
Payment of compensation.
Slowly.
Thereafter,
Slowly. There is a declaration.
Declaration under section 3D2, my lord, or subject to notification 3D2. On the publication of the declaration on the subsection 1, lands are based absolute to the central government, free from all encumbrances.
This is like land acquisition only. Yes, this is like land acquisition of the 1894 Act itself. Yes.
But the old act is not applicable to the land acquisition under the Index Act 1953.
That's right.
Thereafter, my lord, the land acquisition officer has to notify under section 3D3. Publish a notification inviting claim from the person having interest in the land.
Correct.
And they will notify where they will appear and how they have to file the claim under section 3D4. After receipt of 3D3 and 3D4 complaints, thereafter 3D1 has to be determined by the land acquisition officer regarding control.
Award has to be.
Amount vesting on the 3D service.
Is it award or not?
It is award.
It is award.
It is a land acquisition award. You have to follow the same 3D7.
Okay.
That is why any person who is agreed by the award passed by the
Can challenge.
But we have the right to approach the arbitrator under section 325. Which indicates that you are saying then turning what is there. If the amount is the final placing, if the amount determined by the competent authority under subsection 1 or subsection 2 is not acceptable to either of the parties, that is the first of issue.
They can prefer a proceeding under 3G5 to the district judge.
Now, before the
collector of
since as for 3G6, the subject to provisions of NS Act 1956. The provisions of each arbitration
for such proceeding.
Therefore, my humble submission is here is a case either of the parties. What happened in this case? Here is a case the appellant, who is the landowner, he has acquired he has received the original compensation from the land action officer on 25 to 2017.
Now let us see. Now on facts they have to say. Yes, we'll come to your opponent here.
He is basically
beneficiary.
He is national.
NHA.
He is the NHA National Highway
Acquisition body.
Well, the very anxiety of the National Highway, my lad, before your lordship, my lad, will clearly demonstrate this is a surrogate litigation by National Highway. I'll demonstrate.
Your point there, he is saying, since it has travelled to the 227 court, now it cannot come in intra-court appeal.
With due respect, my lad, my learned friend has fallen into his own trap. Initially, my lad, the order passed under Order 21, Rule 97.
Obstructor supplication.
Yes. But when the matter is being put to execution, there were so many hurdles in the execution being carried out. So lastly, my lad, an application was filed under Order 21, Rule 97. Yes, CPC, my lad.
CPC is applicable.
That is what I'm saying, my lad.
No, we want to know whether CPC is made applicable by the Act.
But it is on the Section 36, subsection 3 of the Arbitration Act. It says so far as it will be in accordance with CPC. But why I am saying, I'll also explain, demonstrate that also. Well, once Order 21 Rule 97 application was filed, which could not even conceived of in the wildest of imagination. Because this is a money decree, basically, if at all we can think of arbitration. Order 21 Rule 97, as we all know,
it is obstructors of possession to the taking of possession.
Exactly. And more so, Order 21 Rule 97 happens only after the decree is passed.
That's right.
It is not something which was available to be raised at the time when the matter was pending.
Correct.
It is post.
It is in such an order can be made 97 to 98, 99, 100, 101, 100 to 103.
Yes.
103 makes that order under 97, 21 or 27 a deemed decree.
Is a deemed decree appeal. Appeal lies against.
Appealable.
Exactly.
Appealable, as if it's a decree.
Now, Order 21 Rule 97 rejected by the executing court. Against that, one 227 application was filed before this honorable court. That for the best reason best known to them, my lord, the 227 applications were allowed to be dismissed for non-removal of the defect. And then, my lord, a 226 application filed for against very same relief, my lord, challenging Order 21 Rule 97. And the order passed by the learned single judge is in that 227 allowed to be, my lord, dismissed for non-removal of defect. Then 226. And in 226, this is the order passed. I'm sorry, my lord, the facts have been misplaced.
Now, how can that be 226?
No, that has, Lordship may kindly see the application which has been filed.
What provisions a lawyer will quote in the pleading of his client is irrelevant.
Well, even the honorable single judge has held that 226 is maintainable in view of Whirlpool. That was the
Whirlpool difference. Whirlpool spoke of doctrine of alternate remedy.
Well, that is what has been held by the honorable single judge.
Two aspects.
Yes.
Kindly appreciate.
Exactly.
The doctrine of alternate remedy may be invocable either in 226 or in 226. This is what Shirwai says.
Yes.
In his commentary, great commentary on
Exactly.
constitutional law of India. All right. Therefore, you cannot travel to Whirlpool at all. Whirlpool is can't oust a litigant who knocks at the doors of the High Court, be it 226, be it 227. That is point apart. Now we have to decide whether order is made under 226 or it is made under 227,
correct,
regardless of their employment in the pleading.
Correct.
Correct?
Correct.
Now, because of one judgment which immediately strikes to my mind is Mirror versus State of Maharashtra. 9 AR 65 Supreme Court, page 1. It is reiterated. In 2023, it is reiterated by Justice, Honorable Justice Chandrachud, Dr. Chandrachud. Therefore, now we have how you are going to maintain Naresh Sridhar Mirajkar, correct, versus State of Maharashtra, which my professor used to say for hours, 67 Supreme Court.
So can I bring your lordship one order?
Yeah.
That's 17, 11, 20, 25 round.
17 or 18?
No,
17,
11, 20, 25.
Let us.
Order number 1.
By the coordinate page.
No, by the in writ appeal, my lord.
By the coordinate page.
By the coordinate page.
Oh.
The 3.1 of the order.
That's the reasoning given by the coordinate bench for issue giving you the interim relief. Interim relief. Yeah. Yes, proceed.
And well, when this 226 application was filed, the very question of maintainability was raised before the learned single judge. Lordship may kindly see page 284 of the brief.
It is rejected.
No, my lord.
Allowed.
Lordship may kindly see this order.
No, you sell.
I'm just
You are here to argue.
Yes.
Look, we believe you. We have no reason to doubt you.
Well, the learned single judge left the question of maintainability to be argued at the first instance. With regard to
Then what happened?
Well, thereafter, that was never taken up. When it went to another bench, well, never taken up. And your lordship will see at page 210, that is the writ application on which the impugned order was passed. That is at page 210, my lord. That is the writ application filed, my lord. And the prayer is,
yes,
at page, my lord, 232.
Who went to order 21, rule 97?
It is the present respondents 1, 2, and 3.
They are owners of the property.
They were initially, before 2012.
They were not owners of the property.
No.
Just to give the foundational facts.
Yes, they're not.
When the preliminary notification was issued.
Yes, Lordship may kindly see the date chart in the
date chart.
Yes.
Do you have a hard copy with you?
Yes, no, in the.
You don't have hard copy?
Yes, yeah, it is in the writ appeal, madam. Page number C.
You appear for the owners.
For the owner.
Owner. You appear for the, Mr. also appears for the owner. There are multiple owners.
No, one owner, madam. Both of us are
appearing for you. All right, you appear for the beneficiary.
National Highway.
National Highway is the beneficiary of acquisition.
Yes.
Yeah. And you appear for...
I am appearing for the daughters.
Daughters?
Daughters. The shareholders. The shareholders. Please. The shareholders.
Shareholders.
By ignoring whose right?
Sharers. Shareholders in company law.
Co-sharers.
Co-sharers.
Co-sharers. The ignoring their right, sale deed was executed in their favor. It came to the notice after the award was passed. So therefore, they filed the petition before the executing court under section 47, read with section read with order 21, rule 97 CPC.
Who sold that property?
Sold, brothers have sold the property by ignoring the right of the daughter.
How many brothers, how many sisters?
Three brothers and 3 sisters.
Are they Hindus?
Hindu. Scheduled caste.
Hindu. Scheduled caste?
Scheduled caste.
Scheduled caste or scheduled tribe?
Scheduled caste. These persons.
Why are is it a magistrate court?
No,
why have you called them here?
They have come to file their vaklana. Today we are appearing. Today, by order of your lordships, today we are appearing.
Are you ready in the matter?
Lord, I am, so far as the merit is concerned, I am not ready.
Which date you want?
Fully ready.
Which date you want?
Lord, the lordships.
Choose a date. Matter lies in a narrow compass.
Yes, Lord.
You have understood?
Yes.
Choose a date.
Next week, Lord. Any date, Lord.
On this matter on 10th of March. 10th of March, all right. Agreeable. As requested by
yes, sir, 10th of
all learned counsel consents over.
10th of March.
Right.
Interestingly, when the order was passed in the executive court, they challenged the award that has been passed.
Yes.
No.
Yeah, of course.
That's not for the matter. That's why the pleadings has to be seen. And what the intent of the parties to challenge, those are the determining factor whether it's a 226 or 227.
under Order 21, Rule 97, decree cannot be set aside.
Quite right.
Decree remains intact, but for those who make the case under those provisions, their possession is protected. That protection order partakes the character of a deemed decree because of Order 21, Rule 103. That is the law which we have got.
Right, Miller. But the fact remains.
Anyway, if you are ready, you will take up the matter.
No. I have
Then
not-
don't argue the matter.
And I'll address your lordship on the question of maintainability.
That's all right.
Interim order to continue, Malad.
Interim order to continue till next date of hearing. Yes.
Item 15.
Your lordship fixing it to 10th March.
10th March. That take up with preparation.
Yes.
And make your notes also. Okay. All right.
Item 15.
15, my lord, that matter wherein the non-submission of the property statement within due time.
We wanted to know
Two questions.
that advocate who appeared in the first court, not you, this matter. The learned additional government advocate, last time you said that he had made a submission that they can file the declaration within the extended date.
Yes, ma'am.
Where is that extended date?
My lord, that was a mere submission before the court, my lord. In fact, I have checked up. Two
There is
times,
no such date at all.
2-time extension was made, admitted.
But on that basis, others gave the declaration and you accepted them.
My lord, that is for the year 25, my lord. So far the 24 is concerned, this is confined to 31st January 2025. Then it was twice extended. That my lord has put a question whether, when it has been fixed, can you extend it further, whether by it's a government decision and the rules of businesses of Orissa, whether that was available or not, that was available. And apart from that, my lord, so far the conduct rule is concerned, there is a relaxation in clause 31, my lord. That is made available. Under that clause, twice it has been extended, and to that effect, because it is in the HRMS portal, online portal, that I have received the details of that HRMS portal, my lord. I can submit it before. Twice it has been extended by Secretary and the Chief Minister. That I have given a certain notes for kind appreciation. That I have annexed so far the noting is concerned.
Your Majesty also directed us to
Okay.
prepare a small.
You also give yours. Who has got power to relax?
My lord, clause 31 may have a.
The government has power to
Yes,
relax.
yes.
Who passed the orders of relaxation?
My lord, this is moved by the Secretary and Chief Minister has signed also. I have
Yes,
given.
so it is government only.
Yes, that I have given also. The exact, the order sheet, my lord. All notings in the heading of. Twice it has been extended.
Where is the Chief Minister's note?
Here, my lord, all notings after 5 pages. my lord. I have given. Given.
No,
all
which is the note which carries the signature of Chief Minister? You said Secretary and Chief Minister.
Yes.
Which page? Page number?
That I have not numbered. My lord, this is in the heading. No, sorry.
This is all secretary had it.
Up to 19 you have made, pagination you have made up to 19. Thereafter you have not made all that.
All notings in the heading of all notes.
No. If you paginate, we can look into. Otherwise, we will simply throw it in the dustbin.
Can it be passed over?
You have to paginate.
Paginate. Ask your friend beside. Why do you not paginate? That what applies to government advocate applies to applies to government advocate also. Otherwise, you will be spending unnecessary time. Valuable time of the court. We cannot launder that way. We should be on same pages. When you say a page number, when we turn that page, we should get what you are getting.
May I am plugging. Supposed to be.
Only pursuant to the noting,
Yes, ma'am.
any order has been passed.
Yes, ma'am. There
Where
is
is that
there
order?
is. But this is noting number 415, 412 million.
412.
Yes,
You are
ma'am.
right.
Yes, ma'am. Third para. It is pertinent to mention, million. May I read it?
Yes.
Here that in terms of the Odisha Government Service Conduct Rules 2021, Conduct Rules Property Return, page number 1, Government of Odisha has made it mandatory for all state government employees to submit their property statement online in HRMS portal without any failure, since it has been made a prerequisite for promotion. Miller. The relevant point, Miller, next page. Miller. Noting number 414. Yes, ma'am. Next page, ma'am. Noting number 414. Very good. This is note Seva Purna Chandra Malik, Dex Officer. We have received number of representations from the government employees associations praying for extension of time limit for submission of annual property statement for the year 2024.
Extended of 28 minutes.
Thank you. This is extended by the Chief Minister up to 28 February 25.
Exactly. The next page is the next extension. It starts from noting number 443.
443?
Yes, ma'am. Next page.
All right.
I am giving the details.
Extended by whom?
Extended by the same Lord. One page thereafter, Lord. It is, may I read the noting number 461? That will be relevant, Lord. 461.
461 after 2.
461. That will save the time.
Yes.
Up to 31/5/25.
Exactly. Indeed, my lord, twice it has been extended.
Huh? Yeah.
My lord, it was, as per the rules, my lord, it was 31st January 2025.
Where is the order issued pursuant to this? This is a note. Apex Court said note sheet is not an order.
Other day, my lord, sir, directed that how it has been done or not, that I have filed.
Yeah. Where is the order pursuant to
That-
note sheet?
That is available in the writ petition.
Yes, admitted.
This is admitted, my lord. This is not
Order has been issued by whom?
by the additional chief secretary.
That page number? 31/5/2025.
Yes.
Yes.
Have they filed their declaration within that date?
Yes, sir.
They have not.
Thereafter, and two things, madam. It has to submit through the HRMS portal. Subsequently, they have submitted letter. They have submitted before the superintendent of police and on a hard copy. This was never on HRMS. madam.
It should be given to whom, sir? Declaration to be made to whom?
To the secretary. madam.
Not to the
Not to the superintendent. Not to the superintendent. madam.
Is it sent through superintendent to the secretary, or they have submitted address to two?
Addressed to directly on HRMS. No hard copy. madam.
No, that is the portal.
Human resources.
That is the portal event.
That is the portal.
No, whether they have submitted directly addressing to the SP or addressed to the authority through police.
No. Submitted before the
SP.
That is as per the directive of the Honorable Court. Honorable Court, single judge.
That is the finding.
Since directed that today, what happened is, may I be permitted?
Yes, sir.
Without, what happened, my lord? Some persons working outside and for various reasons. That's not condone now because I am appearing for the couldn't submit the property
Even after
statement
the extended.
within 31/1/2025.
Yeah.
For setting up the DP, two things are necessary. One is receipt of the CCRs from all the districts, so that it will be available for the selection committee, and also the property statement. They extended the date of submission of property statement till 22nd CCR, sorry. Extended for receipt of the CCR till 29/2025. Therefore, the same day, the order was passed by the Honorable Single Judge that since their DPC has not yet been held, today is the last date of receipt of CCR. You go and submit the hard copy for the SP, he will accept.
CCR?
No, property statement.
Property
Property
statement.
statement.
You submit
The
it
date
before
for
the
CCR was extended up to September. SCR. Without SCR, they cannot take it.
So what was required for?
This was property statement. So what they
that is the order in paragraph 3(1) of
This also, this court has that. This court has that.
Where is that order?
order dated
Is at page 30.
26/9
Page 38.
29/2025.
Date for filing the SCR.
SCR.
SCR is extended.
Yes.
Where is the extension of date
That is written there, that is not
by for the filing the property detail?
No, there is no extension.
order.
No extension.
No extension.
That was order.
That is why I told that when I must make actually correct.
Two aspects. Filing of ACR required for considering by the DPC for promotion is one thing. That date is extended. There is no debate on that. Filing of property details, declaration,
Expired on
is another.
Yes.
Are they different or not?
Are they
They are
different?
different. So for the first one, there is extension.
Yes.
For the second one, there is not.
And last day expired on 31st May.
30, correct, you are right. So that note sheet, note
Exactly.
51.
After two extensions.
Correct.
Exactly.
That has been done rightly, wrongly. That has been done by the Honorable Chief Minister. Well and good.
May I submit one?
Yes.
In view of that letter, that notes of submission that letter is there, which has been taken notes of by the Honorable or the other bench before the matter was changed. You make kindly look at that.
No, where is the, sir, not that, Monty, sir. We're asking you, you agree, admit that filing of ACR is one thing.
Yes.
Filing the declaration of particulars of the property is another.
Yes.
You agree with that?
Yes.
There is clarity on that.
Yes.
The Honorable Chief Minister's endorsement noting dated 461. Can you see that? It does not relate to ACR.
That's right.
And it relates to property declaration. This is
I'm
what
confined to this.
Understand.
Then, what is the basis for the learned single judge to say?
But the basis is this, that DPC was to head consider cases of all in the eligible zone of consideration for promotion. So these people's list, that list of zone of consideration included these people's names, but they didn't submit the property statement within 31st May. They didn't submit. Then the DPC couldn't be held earlier to the 28th because CCRs were not received.
No, your duty to file the independent of all this.
Admitted. That is why I told you, Lordship. So, what might have played my mind of the Honorable Judge Milord is that no prejudice will be caused. No prejudice will be caused to the state government to take into consideration these people's case, since they are already in the zone of consideration and that list are available with the department. So on the ground of sheer equity below, that no prejudice will be caused. And then your Lordship will kindly see this letter dated 27th November 2025.
Go to that letter.
As your Lordship, which was taken note of by the coordinate bench.
Let us see how the learned single judge has reasoned out.
3-1.
Order dated 29/2025.
29 or
20th 9/2025.
Go to that order.
It starts from page 36.
Para 4 starts from para 4. What's got it?
Yeah.
It is considered that in order to get the benefit of a promotion with due recommendations to be made by the concerned superintendent of a police along with the CCRs of the present petitioner, there is a requirement on the part of the petitioner to submit the property statement detail to online mode by 31/1/2025.
That itself is wrong.
Yes, ma'am. 31/1/2025.
How learned single judge blends your duty to your right to stake a claim for promotion with your duty to file the property declaration. It's independent, right? That is amalgamation. Anyway, next.
However, it is contended that since all the petitioners are field workers and accordingly they could not avail the benefit of online submission, the authorities are not accepting the property statement details of the petitioner offline. It is further contended that unless and until the property statement detail of the petition is accepted by the concerned superintendent of police with due submission of the CCRs along with the said document by tomorrow, petitioners, that is 21/9/2025.
Why 31/5/25 it is?
That was the document by tomorrow. CCR. That is petitioner will be deployed to get the benefit of promotion to the rank of Inspector of Police for the year 2025. It is also considered that the petitioner are ready and willing to submit a property statement in detail offline before the concerned superintendent of a police in the course of the day. It is accordingly considered that superintendent of police in each of the present batch of the
directed to accept the property statement.
Statement details of the petitioner to be submitted in the course of the day offline and take a consequential action in terms of a letter issued by the state police headquarters on 7/9/2025.
Come to 5 now.
And what is
5 learned government advocate says it is not permissible.
yeah.
5.1, where is the reasoning of the learned single judge? As to how he could exercise power of the government. We are judges.
Yes, ma'am.
We cannot usurp the power of the government.
Last time I had given two orders passed by the court by the single bench.
Sorry, that
So
is not,
this practice has been continued since last 2 to 3 years, and all the parties.
right from the days of Ram Javaya.
That illegality cannot be permitted to continue.
Not only that, there is a doctrine of separation of power. So it is not as strict as under the American Constitution. There is a doctrine of separation of powers which Ram Javaya, Justice, Hon'Ble Justice B.K. Mukherjee's judgment. That has been reiterated with more vigor in Indira Nehru Gandhi versus Rajanarayan, 75 Supreme Court. Then how judges will assume the power of the government?
One thing, there are numerous cases where the last date of admission is over and the court on exercising jurisdiction on 226 has extended the date for admission.
How judges will do that? So you have to convince us. They are in appeal now.
Exercise extended jurisdiction under Article.
What extended jurisdiction we have?
That is, and exercising equity jurisdiction. That if no prejudice is caused to anybody, then equity jurisdiction. And the cases has been extended beyond the last date of admission and acceptance of forms by various courts in various high courts, time and again, in order to grant certain relief to the students.
Students are different.
Now your Lordship will kindly come. Your Lordship sees the last order by the coordinate bench.
Which refers to learned advocate, additional advocate's statement before the coordinate bench.
Forget about it. It also refers to a letter dated 27th. Right. 27/11/2025.
That is
last time also your
letter issued by whom?
By
the government.
By the government, my lord.
Which government? Read. Who is the author of the letter?
Statement of the.
That is there in that note submitted by today.
No, that is not supported by the noting. Is it supported by the noting? No.
It is subsequent to the noting.
Who takes that decision?
That at least there.
Every time decision is taken by the Honorable Chief Minister.
Yes.
That indicates the seriousness involved.
Because Chief Minister is the minister in charge of Home and GA.
He is in charge of every ministry under the rules.
Specifically, GA department is under the control of the GA. Here he is minister in charge of the GA department, under who is the police force.
Yes.
That is why all files are going. Written submission.
I have to draw the their written note it is.
Today's note submitted, my lord. Your lordship kindly have a glance.
Yes, sir.
That I have put in my routine of submission at Parasa.
Immediately after the notings, my lord, 27th November 2025. Your lordship got it.
2711.
Yes.
That office memorandum. What office memorandum?
Paragraph.
Office memorandum 27.
Immediately after the noting.
In your notes.
No, that is
notes submitted.
Yes.
By the government will not today.
That I mentioned in
government's note.
Government's note.
In office memorandum. 7126. 7126 order. And that has put in information.
Dated 27th November 2025. Exactly. In clause 3.
On the basis of
another
paragraph 3, my lord.
Clause number 3.
Your lordship sees the subject. Procedure to be followed for promotion of government servants who have not submitted the up-to-date property statement at the time of DPC consideration. As your lordship got it. That is the subject.
That's all right.
Then, my lord, paragraph 3.
This is a promotion specific.
Yes.
The subject matter is if promotion specific.
Yes.
Does it say anything about the extension?
If
of the
there-
state for filing of-
Paragraph 3.
If any defaulting employee submits the required property return after the DPC within a grace period of allowed by the government and is found otherwise suitable for promotion. Where is the grace period allowed by the government? That is 31(5).
31(5).
After that.
After that, which is the grace period?
After the grace period.
But this is not after the
within the grace period.
Within the grace period before, not before the DPC, after the DPC.
Your filing of property returns independent of your right to seek promotion at the hands of the DPC. Recommendation for promotion at the hands of the DPC.
Yes, for those persons who defaulted to submit their written property statement before the DPC is held. Am I correct?
No, I am not agreeable.
No. Here it is very clear. If any defaulting employee submits the required property returns after the DPC within a grace period allowed by government.
Where is allowed by the government now?
After the DPC.
This is 27th November 2025. Prior to that, the DPC has not been held, and 31st.
That's all right.
So what
Where
is
is
that
the extension by the government?
May 25.
Huh?
Last extension period. That is May 25.
May 31.
And
31st May.
31st May.
31st May.
Within that you have not submitted.
That's what.
And that time also DPC has not been held. There. Only military held after
Mr. Acharya, you are here now.
Yes.
For which case? For which case?
Item 9.
Item number 9. If your lordship would permit me, 2 reasons I may seek an accommodation today. Number 1, I am
In
happy.
that case. That's all right, no issue.
No.
We'll have it some other day.
Why
Any reason should be given by the AG.
Voice is completely lost because of acute.
Why AG should give a reason? AG is the first, see, he is constitutional functionary.
No,
For adjournment, he did not give a reason at all.
Precedents.
Which date you want?
Sometime, actually, let me explain.
No,
we
wait.
have, 1 minute. We have set up, it's for the benefit of the petitioners, I am telling the
So
respondent.
you want the extension at our hands.
Yes,
You are not at the hands of the litigants.
that's correct.
So which date you want?
Same time,
Let him say once, then you can
just
make
a
the
minute.
submission.
Man,
Just which date you want?
why I am praying for a little longer date? We have set up a committee under the chairmanship of a chief. Just a minute. If you interrupt, then submit.
No, this is sufficient. You submit, please submit.
Submitting, they started for.
And you are
No.
showing your, yeah.
I am submitting my.
Mr. of the bar.
No,
I am
one
the- Mr. Mohanty, I know what kind of submissions you are making. Please, I am telling my
Mr. Mohanty.
they are interrupting. If I say that
Advocate
he
General, he is a
was also
President Advocate General. We all will become ex at one time.
not like them, because I can't shout. My voice is, I can't 4 people at a time. But I am praying for an accommodation on 2 reasons. Number 1,
Health ground.
because of this voice, I am not able to really argue. Number 2, we have set up a high power committee under the chairmanship of a retired chief secretary, Mr. Ashok Tripartite, who was also incidentally the principal secretary of higher education department for the benefit of the respondents. They are not able to, prepared to listen to my submissions. So it may help them. We are trying to working out what would be the financial implication.
Your benefit.
That's correct. They do not do anything and shouting.
Let them.
I will try to help them. They don't want to, they want to let them argue 1 minute. It's not a matter of right. There is no pension scheme. I will argue 1 minute.
Submission before 2 months.
I will.
There is an English word in dictionary, standard dictionary.
Miller,
Cacophony. This is cacophony.
2 months,
This is
it
not
may take
argument.
2 years.
So what?
Not argument.
There is no pension scheme, they are not entitled, there is no law.
Yes,
We are
that's it.
right. Let it be up to merits. I will merits.
Mr.
Yes, sir.
No, not
Winding up the committee, I am advising the government to wind up that committee and I will argue on merits.
Mr. Acharya, why do you wind up? You have already constituted
No, but
committee.
it is for the benefit, Milord. I do not know what is their intention.
Therefore,
I do not know what is their intention.
No.
It is, Milord, after the present government was formed, it is me who suggested that pension is a welfare measure. We should protect the right and interest of the
how much time you want?
Milord, 2 months.
2 months?
2 months.
2 months is little.
Pension, my lord.
Chala.
We are solve this matter after 2 months. Yes. Yes. Next. Yes, argue the matter. Argue the matter. Call after 2 months. Call after 2 months. Request also. Yes, next.
Item 15. So that letter where there were not 27 November 2025.
Mr. Murthy, we are asking you, where is the extension by the government?
No, first thing,
Is it your...
let me go by step.
1 second, just to understand. Do you want us to construe this as an extension of the period? This itself is extension of the period.
Yes.
Is it? Ask this. Mr. Monty?
No.
It's not. No.
Step by step. And this was issued after the DPC was held and promotions were given for 2024. This letter was issued after the DPC was held and promotions were given. Am I clear? Then subject says procedure to be followed. So let me kindly mark that word. Procedure to be followed for promotion of government servants who have not submitted the up-to-date property statement at the time of DPC consideration, because DPC is already over without considering their case. So those persons whose case could not be considered by the DPC because of non-submission, then what is they have issued this memorandum. 3 says, if any defaulting employee submits the required property return after the DPC within a grace period allowed by the government. So
understood.
May be considered for the subsequent DPC.
Correct.
He or she may be granted notional promotion.
Because juniors may be promoted already, all this is taken.
Might have been promoted.
Now question.
So now, what the only submission is that when that next DPC will be held, nobody knows. I made a submission last time that on the sympathetic and humanitarian condition, your lordship also was graceful enough to say that all right, to take into consideration this answer.
Yeah.
But there are numerous examples where review DPC has been held. So since you are giving us notional promotion from the date of juniors gets promoted and also protecting our seniority, now that the DPC has already been held, even if your lordship holds that the single judgment is good, no relief can be given. Whether it has become a fait accompli. But am I clear?
Yes, we understood.
So, what we are praying is that your lordship may say, and your lordship sees what is the rules now. If DPC is rule 650 of the Orissa police rules. Your lordship may kind of
get one Xerox of that. Take photo. Police Xerox. First page, last page, you get Xerox of that from our team. All right.
650. You know,
Use that, Xerox of that. So it becomes easy for us that way. No, we have not been using issues. Yes, absolutely. Yes, what would be state that is identified by 6 months. I will bring it in all on the boarding, but in the full city for give their book back.
What another?
Yes, sir. Yes, Mr. Mon.
There are all the vacancies in the rank of inspector. And we are to be promoted to the rank of inspector.
Correct.
Shall be filled up through promotion. The promotion of aside the rank of functional and sergeant to the rank of as advice of central chief. That's not happening, China. Then, my lord, this 10 years has been reduced, my lord, to 7 years.
close. Yeah, I'm not going
Yes.
That my learned senior is reading, that is also available in page 50, that gazette notification at annexer 6 to the REIT application also. This can very well be. ଆଜ୍ଞା ଗେଜେଟରେ ଅଛି ଯୋଉଟା 8 ବର୍ଷ 6 ବର୍ଷ ଯୋଉଟା ଅଛି
ସେଇଟା
ଅଛି ଆଜ୍ଞା ଅଛି ପେଜ 50 ରେ ଦେଖନ୍ତୁ।
Yes, notification date, no, that is notification dated 27th of January 2020.
Exactly. So far the age relaxation is concerned in the amended provision.
No.
Yes.
Happens that is
Yes. No, the expansion. Mr. Bhanti, just we want one clarification from you, sir.
Man.
You were referring to OM dated 27th November 2025.
Yes.
Certainly face it again. Then come to last paragraph. Para number 3.
Yes, ma'am.
Kindly read it.
Maybe from the date on which it was promoted and his seniority shall be maintained.
No, 3, complete 3.
If any defaulting employee submits the required property return after the PC within a grace period allowed by the government.
Allowed by the government. He is not extending it.
No.
He maintains distance from the government and himself. Although under the rules, he can be a limb of the government, is another thing. But he has maintained a difference between himself and the crown, the government. Now where is that extension?
If your lordship says that they have already uploaded also that order dated 7/1/2026.
Uploaded by whom?
by the online.
Online HML portal.
Who is the author of that?
The petitioner has already uploaded, my lord.
Pursuant to order
7/1/2026 order. My kindly
7/1/26 order of the coordinate bench.
Yes.
This is only interim order. This is the interim order made in these petitions only.
Yes.
Correct.
all the cases are there.
Is it a final order?
No, ma'am.
Interim order. Mark that 7/26 order put a flap there.
Has your lordship got it?
Yes. Let us read that order.
It is submitted paragraph 2 by Mr. Swasad Das, learned additional government advocate, that by virtue of a subsequent circular and letters, the time to submit property details for the year 2024 has been extended in 31st January.
Where are those circulars?
To 2000.
No, where are those circulars?
Where
are those circulars? You have read that paragraph number 2 of order of the learned the Chief Justice Board. Where are those circulars?
A submission has been made by Saswat Das, learned additional government advocate. Basing on that, where is the circular? Extending time up to 31st January 2026.
The 31st January 2026, you are not even kindly appreciate. And there may be some submission, some technicalities maybe there. But every year you have to upload that property statements within 31st January of that year. So the property statement has already been uploaded by the petitioner.
Uploaded on which date?
Uploaded. But I have free your lordship sees the direction. Since the period has been extended in 31st January 2026.
That we are asking. Where is that extension?
This is extension.
That extension.
That is there in the rule.
From the beginning, let's Miller. 27 may
for a second. That's a normal rule.
That is the rule. As per the amended rule, this is the last date is 31st January 2026 for the year 2024.
Not for the earlier.
No. So that is the admitted position. Nobody will.
As for their procedure, what
I have only prayer before your lordship is that they have uploaded the statement. HRMS portal, so government no relief can be given, even your lordship vote in our favor, because that has become a fait accompli. Now the question is concerned when will we are defaulting candidates, when our case will be considered. They have stipulated it will be considered in the next DPC, but you will be given
retrospective promotion, postal promotion.
Large number of posts are lying vacant. They also require the manpower. And there is a large number of cases where a review DPC has been held because Appendix 72 says it is only on the basis of the service record and seniority they will be promoted.
Yeah.
So DPC will not have to only scan whether we have got any adverse report or not and throw us out if they like or get us selected. So if your lordship can give it, instead of waiting for the review DPC, next DPC to be held, nobody knows when. Your lordship directs that a review DPC may be held to consider these cases of defaulting petitioner at a convenient time that is suitable that will solve the problem.
Yeah.
Instead of joining issues, am I clear?
You are fully clear.
Yeah. Anybody else wants to say without repeating anything?
No, Lord, only what I reiterate, Lord, my submission is already there is a deficiency they have pointed out. We have not submitted our property statement. Now, by this memorandum of the government,
27 November.
No, we have already submitted our property statement through the HRMS. Now, as per their own admission, if we clear the deficiency, then we are also entitled for being cleared in the DPC. And our promotion, our seniority will not be lost because of the national promotion they are admitting. So now only my lord, the limited situation is only my lord fix the review DPC short and statutory. Because we have already complied with the deficiencies.
Anything you want to say?
Lord, I have submitted all this.
Heard result. Perhaps judgment, perhaps tomorrow. Let us.
What my honest senior
I will
committee
say
have
that
given by way of a written note from
Lordship may kindly consider it on the ground of equity and even in consideration having some sympathy.
Equity and sympathy to be addressed.
I've given any short.
Well, given the
short information.
Not all these
Copy be served by
in this regard, my lord, all this I
You want to compile them?
I compile.
Give that. That helps us. Take all circular. Rule position also. You have
Everything
I have given the details also.
No, my lord, from the beginning leading to this. I'm giving all this. Compilation of.
and there is a order of the coordinate bench to that effect that is if before 31st January.
No, therefore we wanted to know on what basis learned advocate
No, my lord,
said that.
it's a submission, but there was no such extension. Other day, my lord has clarified.
We want to ask you, is it a wrong submission?
It's a wrong submission.
Oh.
There is no such extension. However, it has been
Mr. Mohanty submits that. The submission.
possibly inadvertently the date was missed.
Learned additional government advocate before the chief justice.
My lord,
Normal. That is normal.
Extension of the period. And wrong.
That is normal date.
That we understood.
Yeah.
That is the
31st January is the normal date, but it was written on
of the particular year that you have to give it by 31st of January.
Why the Honorable Advocate made this submission?
In which you have also mentioned about 2025.
At para 7 of my submission, I have mentioned why the Government Advocate and pursuant to query made by the Honorable Coordinate Bench.
He only said rule position. He said only
Yeah, rule.
31, 1 or 2 years.
my lord, possibly it has been 26. In fact, it was January 25. 25 is the admitted position. Property details for the year 24 has been extended to 31st January 2000. No such
No,
extension.
31.5.
31.5
31.5.
is the second extension.
Section
And
extension.
in normal rule, what is the time?
January 31st,
31st January
2025.
of every year.
Every
Every
year.
calendar
You can say
year.
every
That
calendar.
is what.
My lord, just a moment.
That is the rule position.
I've given the circular. Just page 10. Just have it. Just have it for a minute. Page 10. In 24, the extension, what is the extension? That is elastic in nature. Extension of the time for submission of property statement in HRMS portal on the for the year 23. It is in the month of 11/9/24.
This was happening.
I say the kind of the period they have set the prerequisite. It is elastic in nature, and as per the from time to time they have also extended. And here the only limited point is they have been extended. Then we have approved the Honorable Court, Honorable Single Judge has directed it. Although they are extending, now the court has extended. And in pursuant to a coordinate bench, there are a series of decisions because of this.
The rule specified the specific date.
Next.
The rule is not mandatory. It shows from the conduct of the government that it is discretionary. And if the government uses discretionary power, you are not can use this.
Coordinate bench
We have the to be addressed.
decision of coordinate bench to take it.
Right?
Coordinate bench decisions to take.
What is that coordinate?
Last year's.
Last year, all
Last year
years.
that was extended and they gave.
No, we want to know what whether judges should run the government is the question now.
Yeah.
Whether judges should run the government or government should run the government. Now, how judges will say, extend we have not appointed all those people. Since the government has to do certain job. When it does not do, then your relief is here.
Welfare state.
Welfare state, therefore, he will do everything.
My lord, in 226.
Let us see. We will consider all your contentions.
Okay.
Item 16?
Yeah, next.
No, only your Ratchmak inside will not be the early date for holding the petition.
In the event appeal to be dismissed. In the event appeal to be dismissed, then a direction to be issued to the government to hold the DPC without broking delay, since it will have repercussions on the litigants. Okay. Says Mr. Mohan.
In item 16, my lord.
I am first respondent.
Yes. Lordship directed me to deposit 6,000 rupees.
Complied. You can do it.
No, it is not complied. 6,000 rupees not deposited as yet.
I'm told it is compliant. I have
No,
I do not have a senior.
I have not.
Wrong lawyers have said that they have received.
So application rejected and appeal also rejected.
Receive କରିଛନ୍ତି? If they have received, I do not.
Receive କରିଛନ୍ତି.
Then ଅଲଗା କଥା ଅଛି.
What is your submission?
This is receipt showing the noting is.
Receipt showing, my lord.
That is a communication gap.
Communication gap.
What is the matter, Mr.
Matter, my lord,
G?
it's a matter relating to the recruitment of the year 89, 90, 91, etc., my lord. So we shall have to travel many ways, my lord. Lordship may call this matter some other date. On which
The matter related to pension for last 3 years have not get a pension.
Another matter is also pending.
No, that has been withdrawn. That has been withdrawn.
No.
Promotion matter.
No, it is not there. It was remanded from Supreme Court.
Which is that matter? We'll call that matter.
That is a special
let me know that, Miriam.
That is a special bench constituted.
But the matter has been already decided in Supreme Court.
Supreme Court has remanded the matter to this.
My lord, I'll check it up.
Let me have a copy so I can also examine that.
I'll check it up. So the Lordship may call this matter some other date. So
pension matter not getting now.
No, I will not take so much of time here.
Anytime.
Next.
Item 17.
Listener wage loan that is paid for 17 months.
1 second.
Not the
What did bench sent you for mediation?
That's
my lord, they did not agree, my lord.
They did not agree.
My lord, my case is
Who is the counsel for petitioner? You are for bank.
LIC, my lord.
LIC, banking. Okay. Yes, sir. What is the amount due? Outstanding amount?
My lord, 2 loan account, my lord.
Yes.
In first loan account, according to them, my lord, in the first 3 loan accounts, my lord, all are house building loan. One is liquidated, my lord, closed, and the other 2 is, the second one is for 1 crore 61 lakhs.
As on?
My lord, disbursement was 1 crore 61 lakhs.
When it was?
It was disbursed in 19, my lord, 2019. Then I have the Lordship may kindly see annexure 2, my lord.
Third loan is?
My lord.
Third loan is?
Third loan is for 1 crore 63 lakhs. But release amount is less, my lord, that is.
Which year?
Of 2019, my lord.
That is
All 2019. All
Yes.
3 accounts are from 2019.
My lord, 19. And your Lordship may kindly see annexure.
How much money was released under the third account?
Third account, my lord, it was released. It is not there, my lord. Sorry, my lord, sorry. 1,33,77,000.
1 crore.
1 crore
37.
33 lakhs
33 lakhs.
77,000. That was disbursed on 26/3/2019.
All are in 2019.
My lord, yes.
Yes.
Now, my lord, your Lordship may kindly see annexure.
What is the amount due as of now?
And when I filed the writ petition, the amount due was in the 2 accounts. It comes to, my lord, 1 crore 62 lakh 76,000 some odd, my lord.
as per annexure 5 and 6, annexure 6 series, my lord. 1 crore 62 lakh 76,785.82.
As on which date?
Based on the date of notice.
Yes, my lord. Date of notice, that is
on 10/12/2024.
my lord. 26/12/2024.
26/12.
Annexure 6.
Now how much it will be?
My lord, now they have given in the mediation, my lord, in the first loan account, they have said on 24/9/2025.
No, first loan account you said it's already closed.
My lord, that is closed. Now, second and third. In the second, they have given 1 crore 63 lakhs 65,540. In the third, they have given 86 lakhs 19,351. In that account, my lord, settlement account, they have charged, my lord, they have stated the disbursal. Your lordship may kindly see this, my lord. Yeah.
Okay. Yes, no, what should be done? They are not agreeable with that, no?
My lord.
Then what's our jurisdiction?
My submission, my lord, there is a one-time settlement scheme, my lord. This honorable court in an earlier petition directed to take a decision. They did not take any decision. They did not take any decision as yet. Now, taking the aid of COVID-19, my lord, during that period, the interest and penal interest, compound interest are not to be charged.
Where is that law?
My lord, I got this petition today, but it is more than 70 pages, so I do not know this, my lord. That is stated in 2021 volume 8 SCC 511.
Yes, between
small scale industries, manufacturers, association.
There is a small scale industries act also.
Yes, it is.
Yours is not industrial loan at all.
My lord.
But in housing.
Yeah, in this scheme, house building loan account is also covered, my lord.
Which paragraph?
My lord. Paragraph 99.
Read.
Now, so far as the charging of penal interest, interest on interest, compound interest during the moratorium period is concerned, it stands absolutely on a different footing. At this stage, it is required to be noted that in the fact, central government has come out with a policy decision subsequently by which it is decided not to charge the interest on the loan up to 2 crores. However, such relief is restricted to the following categories: MSc loan up to 2 crores, education loan up to 2 crores, housing loan up to 2 crores. I am coming on housing loan. So, my lord, my submission is
it the interest on interest?
My lord.
Penal interest.
Yes. And compound interest.
Where is the penal interest in your case?
My lord, your lordship may kindly see. I have given the copy. They have filed. Your lordship may kindly see.
No, where is the penal interest?
My lord, penal interest is penal charges to 25,74,379 in the second case, and in the third case.
For what period it is?
But total they have charged. Nothing is there.
No, then the court will not undertake all investigation. You should go to the LIC. You should sit across the table. You should ask them the.
I have filed an application before them to give me the statement. They are not giving. Instead of that, in the local law, they submitted it to me.
What do you say about the judgment of the apex court?
I have also that. I am also relying upon apex court judgment.
Which
yes, that was regional cooperative society. That's division bench judgment, and it was also followed.
Of which year?
Of regional cooperative society was 2021.
21. Which is of your year?
And this was subsequently followed by coordinate judge judgment of this court, division bench.
What is this judgment is of which year?
My judgment is, my lord, that is.
This was followed in 2022.
2021 volume 8 SCC 511.
2021,
Volume 8 SCC.
when the date of the
Judgment date is 23rd March 2021.
But this is December 2021. 15/12/2021.
I have to go to that.
You go through and you will give short time, you go through.
Yes, sir.
And come back.
Yes.
As between two judgments of the apex court.
Yes.
The one which is the latest which should be followed is the judgment of the apex court.
Provided the earlier one is followed.
No. If two judgments cannot stand together on the same principle,
My lord.
the latest judgment should be followed. Call week after next at the request of. Okay. See, the statement is made by the central government. Whether central government statement will bind your client. Because your client is governed by the provisions of LIC Act. There is a separate statute. That aspect you have to look into. To whom that applies, to whom it does not apply. All that you have to work out.
And also the penal interest if you have been charged.
You have to do the breakup.
Without considering my concession, your lordship, he can additional interest we are foregoing. Let him pay that. Additional interest we are
how much?
foregoing.
You have to
Without recording my concession,
How much additional interest?
that around 25 lakhs or something. Yes, they can pay that.
My lord, I have amended my lord. Your lordship kindly see. They have charged surface charges. My lord, 24,000. Recovery charges 8,43,290.
Making my concession.
And
we are willing to forego that additional interest.
updation charges 12 lakhs some odd.
Yeah. You take him to your bank, sit across the table, and just have the discussion.
Lordship, fix a date so that.
And by now, towards interest, I have paid more than 2 crores, my lord.
If you can loan
Fix a date. Lordship, fix a date. They will appear on that date. I am instructing my client to take it.
Both the sides having argued the matter for some time are now agreeable to the suggestion of this court that they should sit across the table and explore the possibility of diffusing the difference. First time, the bank shall, the LIC shall fix a date on which date.
Any day, your lordship may fix it. We are not, your lordship discuss any date.
Both the parties to do this, on 25 on 20. Is it all right?
25th of February.
On 25 February 2026. And hopefully to come out with the positive result. First time. All right.
Let him go and paying the EMI. He has stopped that. After 81 years,
My lord,
stopped paying.
last week, my lord, one bereavement is there in their family. One is expired, so they can attend or not.
Yeah, when it was? When it was?
2 days before, my lord.
Just 2 days before.
Yes.
But the installment fell due when?
My lord, as per the order of this Hon'Ble Court, I have deposited 40 lakhs.
That's all right.
Thereafter, I have not paid.
You have to make the payment. No, otherwise,
You are not pay direct, my lord. 10 lakhs or 20 lakhs, I will pay.
Not what the 10 lakhs. What is the amount due? Of that, you have to pay 30%, 1/3 of the amount you have to make the deposit. Even to sit there. Now, what is the amount, net payable amount is?
My lord, they have recalled because it became NPI, it has been recalled.
Now, what are the installments due? At least those installments you have to make payment and go. You cannot run away with the money of
My
others.
lord, yes, my installment is due is, my lord, 56 lakhs some odd.
How many installments are due?
My lord, it is up to 2039, my lord, 29.
29 installment.
No, my lord.
Loan is up to 2029.
That's all right. Now assume that
120 installments.
loan is not recalled.
Loan is.
We are telling you, assume that it is not recalled, and you are a very scrupulous borrower. If you are not, we are asking you how many installments were due.
My lord, I'm giving my lord. My lord, per installment, 20,000, 2,20,000, 24,000.
2,24,750.
Not 2,02,475.
Plus principal 14,881.
Yes, my lord.
2,24,750
plus.
How many months?
That I cannot say.
For the date of interim order, you are not paying.
No, yes, I am not
No,
paying.
interim order said pay the lump sum.
40 lakh.
Yeah, that he has paid now.
Yes.
Is it not?
Yes, yes.
How many installments are due as of now? The time is spent only in this. We have become bankers now. You have reduced the constitutional court to the level of a banker.
More than 14 installments. If calculated upon 28/1.
Last year, January, interim order was passed.
11 months and 12 months.
12 months.
12 months.
12 months. This the parties will do provided petitioner pays all the 12 installments on or before that date. Failing which the petition runs the risk of dismissal on that ground. Okay.
Date may be.
We have fixed 25th.
25th problem.
Which date you want?
Any first week of March.
Call this man. See, now instead of 25, you make it the 5th of
March.
5th of March, 6th of March. Okay. Otherwise, we'll dismiss the petition on next week. Subject to that, interim order shall continue. Okay. Not repaying. Yes.
Item 18.
This matter I took time, 2-3 days time. I am filing an affidavit. Only perusal of course I know the fate of the case. Only I will submit this document, page there, or see my passport. I need 2-3 days time may be given. Any date. But by day after tomorrow we'll file the affidavit.
On 23rd.
24th or 24th. Yes.
24 February.
Monday I have some problem.
All right, no issue. 24, 25, whichever date.
Yes.
Okay.
According to
Yes, the request of GST. Finally. Request for further request for adjournment shall not be entertained. Yeah. One more matter. Yes, please.
Item 19.
Short pass over, Your Honor.
Pass over.
Item 20.
Yes, sir.
May I please, madam?
Yes, sir.
So these are the two appeals before Lordship Pillars. These two appeals arise out of common judgment. The Lordship, for the sake of convenience, may kindly take up Miller's writ appeal number 966 of 2025 minutes. That was the lead case also before the Honorable Single Judge Miller's.
Yes.
Because here, precisely speaking, Miller's, in both the writ appeals, Miller's, so far as the writ appeal 966 of 20 is concerned, two issues are involved. One is, Miller's, the reduction of cash credit limit, Miller's.
Cash credit
limits, because the respondent before Lordship Miller's is a borrower, Miller's. And the appellant before Lordship is State Bank of India. And loan by way of Miller's cash credit accommodation was granted since 2006, Miller's. And 14 crore was sanctioned in 2000 Miller's 12 Miller's. And ultimately, Miller's, in 2022, Miller's, 14 crore accommodation, this cash credit limit was granted. That was subject to some conditions, Miller's. Unless those are complied with, Miller's, bank has the right, Miller's, even to, Miller's, seize the benefit of this cash credit limit. These are, the arrangement for the purpose of facilitating, Miller's, the operations, business operations.
So let me precisely speak the issue, then I will highlight each of the issues for us. So that's reduction of cash credit limit, that was challenged, and the honorable single judge held that was contrary to the banking regulation, so that is not, and you have to restore the limit to 14 crore. So you reduce because of the unhealthy financial behavior of the borrower, because he could serve the interest and other liabilities and all that. Whereas now it is reduced to 6 crores. So against that, honorable single judge directed, no, you restore it to 14 crores again. That is up. And second is capitalization of penal interest. The petitioner, in the writ petition, referred to a Supreme Court judgment, saying that capitalization of penal interest is not permission. We don't have
That is the penalty on
capitalization of penal interest means, supposing a borrower violates certain RBI guidelines or circulars or the terms and conditions of the grant of loan, because as my lords knows, in case of particularly unlike term loan, in case of cash credit, not only you have to always maintain the balance which is sanction level, which is granted, you can't exceed that, but you have to also make adequate provisions to ensure that the interest liability which accrues from time to time is being paid by you. That is one. Next, stock statement, the sales statement, balance sheet, profit and loss account, insurance to secure the goods, so many compliances are there which are to be complied with, because if they fail to do that, then also the bank will be there to impose penalties. Apart from that, also your chief will be thinking of two things. One is the credit limit. Supposing 14 crores we have sanctioned credit limit, but the drawing power is not the same as that of the credit limit. Drawing power is determined as per the RBI guidelines. So drawing power, depending upon the computation which is available under the guideline period, it can be 13 crores or 13.5 crores.
14 is the ultimate.
Exactly. That's a higher ceiling. Beyond that, it cannot. And also, the borrower has to ensure that he draws the amount up to the drawing power or the CC limit, as the case may be.
Whichever is lower.
Exactly. If it is at par, then he can have the benefit of using both. If the drawing power is less, then he can
reduce.
Exactly. That's and the other writ petition, the second one, that is also covered by the common judgment, that is against the NPA. NPA means non-performing assets.
Yes.
That's non-performing assets classification is given to an account only when a particular account becomes out of order. That's what is out of order. Out of order means dealt in by RBI guidelines. That says that if you do not make payment of your interest liability or the whatever, you have to maintain your account by serving interest. If you fail to make payment for a continuous period of 90 days, then the account will become out of order. Apart from that, as I said, let me repeat.
Out of order is equivalent to NPA.
No. This is the consequence. If the accounts becomes out of order, the consequence will be classified as
risk of being certified as NPA.
Exactly.
That's a trigger point to initiate the action for NPA.
And that will lead to recalling the loan account.
Correct.
So those are the consequences. Now, what has happened in my case, so far as the other writ petition concerned involving NPA case, because as of the date of filing writ petition before the honorable single judge, the NPA classification has since long been withdrawn. Because he has made a complaint that my account is classified as NPA on 30/12/2024. But the bank, after getting payment from the borrower, he has paid payment.
He has regularized the account.
Exactly. He has paid 50 lakhs towards interest payments. On the very next day, we withdrawn that NPA. So therefore, there is no cause of action survives to file the writ petition.
Even then, writ appeal also is not maintained.
Exactly. So far as that issue is
writ appeal we can say as infructuous because of his statement.
I'll be happy, my lord, if the writ appeal is infructuous, then the honorable single judge's order has to be complied with.
So far, what complied with? It has now, there is no NPA.
No, I'll submit.
Okay. So far as my stand is,
come back.
Yes, ma'am.
Okay.
So before I take my lord's attention to impugn judgment, my lords, there are 2-3 documents, my lords, I would like to refer to your lordships, my lords. From WPC, the data bill number 966 of 25 minutes.
You said credit facility mentions maximum limit. That does not mean entire limit can be exhausted by him.
Absolutely.
It all depends upon his CPL or something like that, which is the the RBI guideline for that.
Which guideline is for that?
Guideline means RBI circular is there, minutes. Drawing power.
That is part of the record.
Part of the record. Yes, may I submit? Yes. Now there is some development. So your lordship may not have to, or I did not have to bother your lordship with so much of argument, minutes.
Correct.
Even if I supposed to minutes bring to all, now what has happened? The whole of the grievance of my friend minutes is repetition before the honorable single judge. And here I responded also. What he says that the initial grant of sanction of the CC limit 14 crores minutes, that was reduced to 6 crores in a phased manner. Because this phasing out of this limit is because of non-compliance or not proper compliance of the guidelines, which is that, and also terms and conditions sanction letter. Because what we said him that we're going to reduce because you are for 2 years, the loss was 1 year. It is also recorded in the order of impugn judgment. One is 7 crores somewhat, the other loss is 3 crores, and they have zero turnover. So this is where they stand, no cash flow. And no cash flow. So those are the situations where bank is gone. And the auditor of the bank has also earmarked the account to be a stressed account. So this is how the account status of the account is. So as a banker, bank is also it's public money. We have to be also very watchful to see that it is utilized in a proper manner. Now what is happening? Because we issued a letter, that is on 14/12/2023. 14/12/23, we are phasing out the available limit that we are going to reduce it first 14 to 9 crores, then 1 crore each per month, which will be reduced to ultimately 6 crores. And that communication dated 14/12/2023 was acknowledged, received, and he also accepted that phasing out of the limit.
Where is that acceptance?
That is Annexure 2 of the writ appeal. Annexure 2, page 26.
In writ appeal 966 of 2025.
May I place minutes? We understand that we have accepted credit sanction 14/12/23 for reduction of our credit limit to the existing level in a phased manner. Our commitment was based on the expectation of receipt from government departments for our executive.
Therefore, they have applied for enhancement.
Subsequently, they have applied for. What they have done in the very next communication, Lordship will find.
This is which document? Annexure 2.
This is Annexure 2 minutes.
In their WP.
Next, yes. Next, Annexure 3 minutes.
1 second. Annexure 2 is in which WP?
966 to 2025.
Writ appeal.
Writ appeal 966.
966. Correct. 2020. Annexure 2, page 26. That is the acceptance of the borrower respondent. And your lordship will find, if your lordship kindly turn to the previous page, Annexure 1, for a moment, page 25. For a moment, page 25 minutes. My lordship will kindly see account number so-and-so, irregularity in limit renewal continuation. This is addressed to the borrower respondent minutes. The position of the accounts as on date as follows. There are 2 accounts. One CC stands for cash credit, GECL, another term. This is at one terminal account. And 14 crores is the limit. Outstanding is 14.17. Irregularity is 0.20 approximately. Then 1.32, there is no here. Total is 0.20. We request you to regularize the account by crediting the unpaid interest amount in CC account at the earliest. Further, we would like to inform that based on the discussion with Pratap Kishore Ponda, Managing Director of the company, on 13/11/2023, continuation of credit limit has been allowed by the appropriate authority with the following conditions and stipulations. The FBW stands for Fund-Based Working Capital. The FBW limits to be brought down to 9 crore latest by February 24 by deposit of receipts from government authorities for Lakshmi Takki's ROB Sambalpur work order and or any other receipt or cash flow, and further reduction to 6 crores by October 2024. That is reduction of 1 crore every quarter, which I have submitted to Lordship. Meanwhile,
this is sent by whom?
This is sent by bank to the borrower respondent.
In response to this, he replied Annexure 2.
Exactly. This he accepted.
How learned single judge treated that?
No. Honorable single judge, my specific stand for Lordship is that is also at the initial stage of admission before the earlier revision periods. Nothing, no conclusion, no reasoning, no deliberation, nothing. He said that it is to be restored to 14 crores, and this is in violation of the banking norms and the regulatory activities, all that. So that is all, nothing. There's no reason is given, no deliberation. And in the counter affidavit, because what has happened initially in the writ petition, these documents are not there by the petitioner. He has not disclosed to the Honorable Court Minutes. For the first time while filing counter minutes, I brought to the notice of the Honorable Judge, single judge minutes.
Why do you say they are not produced? They are in Annexure 1, 2, 3 as the series of the petitioner only.
Exactly, minutes.
No, you are saying he has not produced. They are produced by him only.
No. This document is a writ appeal at the annexure.
You have produced.
Exactly. These are the revelations in my counter only. Your Lordship will not get this from the writ petition. And your Lordship will kindly.
You said the court need not undertake
exactly
deliberation.
Now
what developed?
Correct. Now what has happened? I am giving to your Lordship two communications. My friend was also not aware. Just now he was telling me he didn't know that. Anyway. I think this will put an end to his grievance. So, Lordship, kindly see my communication 2 minutes, the respondent borrower company minutes, dated 2/2026 minutes.
Now you have agreed to continue the CC limit.
Exactly, at 14 crores.
On ad hoc basis.
14 crores.
On ad hoc basis means on 180 credentials being
It's 180. Limited time. Because
all related documents you have to
exactly. Yes. That he has to furnish all. Because now what has happened, in spite of the repeated communication, that they are filing documents for the purpose of renewal. Those are the mandatory requirements.
What are those documents to which he has?
I have given specifically, but those are there.
Where is that list? Just show
that.
I can also just
correct. Absolutely.
I can look into, because I was also lawyer for many banks.
Well, your Lordship, see in the same letter, we advise them to execute all necessary renewal document 12/5/2026. Every year, the sanction is to be renewed. He has to come and then renew it, and as well as
renew it for 14 crore only.
Whatever the limits are existing, he has to renew. And
you have given proposal. What he says we have to see. What problem he is facing, we do not know. Okay. For renewal anyway, you can give all the documents subject to same this one, instead of, because on merits the orders are not sustainable because they contravene the judgment of apex court. On merit subject to what he will say. Instead of that, now they have stood tall. He is a taller advocate to look at also. Just execute the necessary documents which shall not involve additional liability. Yeah, additional liability, no. Whatever normative liability and accrual of interest, this, that, etc., yes, he will do. No additional liability. Saying additional condition, you will put no additional condition, nothing.
No. As usual,
that's usual condition.
Correct, you are also quite.
But he says,
Lord, it is not that easy what submitting.
Then all right, you have argued your case. Kindly sit down. Yes, argue.
Lord, may kindly see the first writ petition.
No, we are asking you now. Annexure 1 and 2. To Annexure 1, your answer is Annexure 2. You have accepted, you have acknowledged and accepted acquiesced production limit.
I have also said that I got the government contracts, please enhance. So the letter has to be read together.
Understood. Text counsel for the appellant respondent submit that Annexure 1 and 2 have to be read together and not in piece.
And the next point is, my lord, that is the December 2023 letter. They continued till November 2024, giving the limit up to 14 crore. On 8th of November 2024, I was enjoying the limit of 14 crore with a DP limit of 13.29 crore drawing power.
on 13th November, they reduced to 6 crore. Now, there the Lordship has rightly pointed out that where is that RBI circular? No, Lordship.
That's all right. Now they have given this proposal.
No, why they have given the proposal? I'm coming to that.
Yes.
Why they were not giving this proposal? Why they are asking now? I'll address that first, then I'll take it to. In the meantime, what has happened? Because this appeal was pending before this Honorable Court. Judgment was in my favor. 3 points the Honorable Single Judge has said. One is capitalization of penal interest is violation of the Constitutional Bench judgment of the Honorable Supreme Court, Ravindra versus Central Bank versus Ravindra. Penal interest cannot be capitalized. That was where the sanction letter they provided to me, I challenged that. I challenged on 2 counts. One is the principles of estoppel comes in. Milord, I refer to Lordship's judgment, single bench, Milord, the SB State Bank's judgment. When the bank is saying that, okay, we are funding you and the customer invests its money, infrastructure, labor, thereafter you immediately, without giving any reason, without citing any reason, they say that for last 2 years, there was no cash flow. Now the CCA account, it's a CCA account. It's not the term loan account where on a particular date, the installment amount has to come. It's a CCA account. There's an automatic debit by the bank to my account. If there is no credit balance in the account will overdraw. What the RBI says, there are 3 conditions has to be fulfilled for the out of order. One is there has to be an excess amount to the limit to continue consecutively for 90 days. There is no cash flow for 90 days. And even there is a cash flow which is not sufficient to debit the interest for 90 days. Admittedly, by the bank, the account was overdrawn only for a day, 30th of September 2024. 1st of October, I paid 2 crore, brought down to this. That also the RBI says that for the temporary discrepancies like overdrawn for a day or non-renewal of documents cannot be a trigger point for NPA. I'll cite those things. So in the meantime, during pendency and everything, what has happened, Milord, I decided to come out of the bank slowly. Then I suggested that I have 4 properties mortgaged to you before you. You value all 4 properties and give me the amount for each property. I'll pay, that's a partial redemption, Milord, Section 61 TP, Transfer of Property Act. Partial redemption is allowed provided there is a contrary condition in the sanction letter. That's a provision says. So they valued, they deducted 6,000 towards the valuation report. They communicated to me saying that one property is 2 crore 81 lakhs 30,000. You pay. I paid 3 crore 23 lakhs within 11 days. After receipt of that payment, when I sent a letter saying that please return that property to me so that I'll sell it, and again I'll pay it and redeem another property, slowly I'll come out of this 14 crore entire thing. They say that principles of res judicata applies. The appeal is pending before the Honorable High Court. We will not release the property. Why you communicated saying that you did the valuation also? That is where I filed another writ petition challenging that arbitrary action. There, Milord, when I cited Section 61, the Honorable Single Judge asked the bank saying that so was the condition which is contrary to this provision, that parties have agreed that there can't be a partial redemption and it has to be a full redemption. They do not have any condition there. That is where the backdoor entry comes into renewal so that they put that condition. And non-renewal of documents, Milord, RBI says, I'll cite the circular. Non-renewal of documents is not a trigger point for NPA. NPA is confined to 3 points.
No, we have understood. What we are suggesting is, ultimately writ court has to bring about just a transaction in terms of order. Nothing beyond that. Right, wrong, and other things are not important to the writ court. That's the law. Now they are coming forward with this letter, saying that if you execute these things, we will not press the appeal at all.
What? The appeal, the impugned judgment is not for the decrease of the DP limit will. The impugned judgment is on 3 points.
That's all right. Even that will pale into, you can understand. Even that will pale into insignificance because as of now, have you supplied a copy of this memo to him? Just read it now.
But I have read that.
Again read. We are telling you. Read loudly so that together we can read. I'll also read, you also read.
That the appellant hereby files letter dated 2/2/26 issued by the appellant to the respondent intimating that the competent authority has given approval on 30th. That is a memo.
It's a letter. Memo. Letter dated 2 my lord is saying this 2/26.
2/2. With reference to your request letter dated 11/11/2025, 3rd December 25, 30th December 25, 3rd January 26, wherein you had requested bank for continuation of CC limit at existing level of 14 crores for a period till 31st March 2027. This is to inform you that the competent authority has given approval dated 30th January 26 for continuation of CC limit for a maximum permissible period of 180 days from 12/11/25 to 12/5/26 with sanction observation that full renewal proposal needs to be submitted before the expiry of continuation of limit. Hence, you are advised to submit all renewal related documents.
Next page.
My first letter, according to this letter, was 11/11/25. They could have done this.
You want to stand on technicalities. That may not help you. We are putting you alert. We are alerting you. That may not help you. Those who stand with the sir will fall down. Instead of that, now bank is coming with this proposal. Or you want to litigate? Then we know what to write.
No, Lordship's prerogative, my lord. I am not saying
therefore,
that.
think about that.
I thought so.
That as to ensure that the prerogative is
saying.
not exercised against your client. That's the advocacy. Your advocacy is to ensure that the power holder exercises that power not to the detriment of your client.
Lord, I was in lurch, my lord, for 3-4 months. They made DP limit 0.
Now,
based on what?
Now all that has happened. They have come out with this proposal saying that we are doing everything to you as before.
Apart from, if I submit 2 minutes, then
you did not come forward for renewal compliances.
He wants to say. He may have some reason. Because there is some fault on your part also. You have also troubled him like anything. Industry runs on the assurance that you will not alter my limit. Based upon that, other people who with subcontracts, etc., with whom he enters into, they are decided. They will ask all the documents, who is your banker, what is the facility which is available to you, whether you will be in a position to run the show or not. These factors will enter the fray of decision making by the subcontractor or to the persons to whom he has to supply the goods, services. If you all of a sudden reduce it, where the industry should go? Therefore, it is not that bank also, though it's a matter of contract, you cannot be that arbitrary.
I understand you. You Lordship have seen the discussion with the Pratap Kishore Panda, the managing director. This all happened, my lords, after discussion only, with his consent. But these are all matter of consensus.
Annexer A1, he had requested to enhance the limit to the earlier level. You can't read, he's right in saying, you can't read our letter in a sectarian way. Holistically, you have to consider. Though he sought for renewal, it was not renewal. It was only restoration of the facility which was available to him. Therefore, he is also, he has some agony.
Lordship, I need not to cite any judgment, my lord. On the bargaining part, the Honorable Apex Court has said that between the bank and customer, who is having the higher bargaining power. These letters, my lord, I will show to your Lordship on 31st December. They call to the borough, they say that please sign these receipts. Till that date, the DP limit was 0. That day, they opened DP limit. They deducted my account of 30 lakhs, transferred to a current account. 34 lakhs from current account transferred again to this CC account. And they again debited 16 lakhs 25,000 towards processing fee. My agony is, my issue is, this judgment to Lordship, whatever Lordship possible. My job is to bring to a Lordship's notice what has happened to this. The penal interest cannot be capitalized.
I have to address that issue.
That issue is also.
The judgment says to reverse that amount. What happened to that?
How much money it was?
Because as per the pleadings bills, available pleadings before the Honorable Single Judge bills, the period which he has complained that during that period he is complaining that is the capital penal interest. That period is 1/4/24 to 31/12/24 bills.
That was 22 bills.
Just a minute. That was 22. No, Lordship, kindly see.
No, apart from pleading.
3167.
Apart from pleading.
Finance.
Whether the capitalization happened for the earlier period also?
Yes.
Earlier, because what we have done, I have in my counter of specifically mentioned that now there is a circular by the RBI bills. Saying that capitalization of interest shall not be done. No. It can only be penal charges. We are no penal interest bills.
Yeah.
So we have been complying RBI circular.
So
what precise?
Now you say no penal interest.
No penal.
Whatever interest you have already taken, what are you going to do to that?
For the previous period is concerned with us. He has not mentioned anything.
No.
Yes, what I am suggesting, that to be very quite correct, what I am suggesting, let my friend make a representation saying that these are the periods we have been agreed by the levy of penal interest.
Yes.
Because they are old matters, extreme old matters have to be checked. We will verify. And because penal
not
interest.
Only verifying if it is claim upon is true.
Correct.
Then you have to reimburse entire that money.
We will reverse.
Yes, you have to reverse with the interest.
Correct.
With the interest we have charged on him.
Correct, Biras.
In respect of that.
As early as November, despite having the Lordship's order.
They have agreed to your proposal also. So that your client will get whatever money he has lost because of unethical practice of the bank. That he will be able to get along with the interest.
I am also not going to the judgment by Honorable Supreme Court. Your Lordship is well aware of saying that without prayer and pleadings,
that is one thing, but it is not a suit.
So that is why I say
proceeding. We can look into the record.
Correct.
Paragraph petition. I have taken specifically that issue.
Period.
Then I am showing to my loss.
Anyway, what I suggest is instead of
we sit together again.
Therefore, what we will say is this now. The bank has come, I'm just giving the format which we want to print in our judgment. Lakh cities.
It is around 1.76 crore.
No.
1 crore 76 lakhs.
2 crores.
I have filed.
Whatever.
They'll say.
Matter of record also.
Yeah, it's also it's in the pleading in a contempt petition. I have given the Excel sheet, the calculation.
Petition can it be basis for
Now you ask your advocate on record to file a memo that so far as penal interest component is concerned, it will be restored to him, to his account. You can appropriate also the amount for the amount due. And with interest.
What I am suggesting.
Whatever interest you have levied on him, that interest you have to give.
Correct.
That is justice.
Let him make a formal representation. Your Lordship direction will certainly abide by and will examine and give.
No,
will give.
Now you have to give a proposal on memo.
You give a proposal.
Otherwise, you have to raise the judgment on merits. There are many aspects which he has highlighted. Not that simple. You can't harass the industrialist that way. Every industry brings money, it generates employment. Many stakeholders are there. Therefore, whatever the penal interest component is there, it is not a small amount. 1 crore, even according to 1 crore 22 lakh.
No, according to him, Millers. According to me, we have already paid Millers.
More than that.
We have not charged any penal interest as per the RBI circular. RBI circular.
Brother, you can do one thing, I'll tell you. Since we have some accumulated expertise in banking law. Okay. We are telling this format to you. You consider this. Otherwise, we'll go on merits, whatever happens is another thing. The first format we are giving to you is to both of you. These the question of examining the appeals on merits now pales away because of the development as reflected in the memo. Memo reads like this. There are two documents accompanying the memo. They read as like this. Okay?
And the other document is the satisfaction and appreciation of the borrower.
No, that will go to the merit. No, that will go to the merit. That will not do. Then the second one is your agreement, gracious agreement with us that the penal interest component would be restored to his account. With interest.
Subject to verification.
Of course. It has to be by calculation only.
If
It has to be by calculation only.
If it has been charged.
Yes.
Correct.
In that correction, he will make a representation.
Correct.
For that, what you have charged, how much money you have taken, the records are with you. You can't saddle him with that at all. After showing that to him, you should allow him to sit across the table, offering a cup of tea if possible. And because he's a customer.
Always he is entitled to coffee, Miller.
Yeah, that part. Not at your hands. Not between you. Even the Mahatma Gandhi ji said, your customer is not your troublesome agent. It is because of the customer you are there. Therefore, be friendly with him and do this. Brother, what is are you agreeable with this proposal? You have nothing to lose. On the other hand, now even interest component you will get it.
2 points, my lord. One point is that on what basis, my lord, before the Honorable Single Judge also, and before your Lordship in the appeal also, not even a single document filed to prove that I failed vis-a-vis to the RBI circular,
Now
to the NPA.
No, you have crossed that. You have crossed the bridge.
Not crossed, my lord, my submission, not submission. Classifying NPA is not that easy, my lord. Today we classified, tomorrow we again reversed. But once account is classified as NPA, it goes to all the credit information companies, including civil. It has a very cascading effect on my business.
If my words still wants to argue, my lords, then my lords, I will take my lords leave, my lords to argue.
He is saying that likely consequences of branding an account as NPA. Once the account is branded as NPA, the reputation in the market.
I'm not getting any finance now.
My lords, NPA is marked on the, just a minute, 30th 12. On 31st 12 it is withdrawn.
But that is circulated to everybody.
Yes, because he made payment. He had not made payment. Once he made payment on 31st, my lords, on the very same day he withdrawn.
That is where, my lord,
he made payment, my lords. Just a minute. All this marking of classifying the account NPA, neither I or anybody can. It's a system generated.
By
System
SOP
based.
it happens.
Yes,
SOP.
Exact system based. System based. System will mark it as NPA.
And next day we have particular.
Banker, neither he can show in favor.
On which date he was supposed to credit that money?
You will kindly see.
We are asking one question.
Yes.
No question of saying and other. Which date he was liable to?
Yes.
On which date you have paid?
He is liable to 30th 12th.
Statement and release.
On or before 31st 12.
First 30th 12.
13/12.
Then he deposited the amount on 31st. So one day there is always a leverage. If party pays in the next date, then the entire tag will not be there. Neither it has been reported to civil nowhere. It is just
my lords,
mechanical.
Just a minute. Kindly see, my lords. Counter affidavit dated 4/3/25 from WPC 56. For a moment, lords. WPC 56/5/25 counter affidavit filed in decided petition. Page is 19. Page 19.
Yes. 30/12. 26 lakh.
Your lords, page 19, my lords.
9,440.
31/12/24. There is a deposit of 50 lakhs, my lords. Last entry. Page 19, last entry.
No, we are asking you when you are supposed to pay.
30th 12th.
Where is that? Where is that?
Because our submission is for October, November, December, for continuous period of 3 months. The deposit was inadequate to make good of to solve the interest liability. That is how, because of shortfall of payment of the, if money is there in the account, that
automatically it is credited.
Exactly. Even if money is there in the account, unless there is sufficient money to meet the interest liability, then also it attracts NPA bills. So that is what it happened, Millers. On 30th it was marked NPA. But very next day, the moment 31st,
he deposited. He credited
yes, immediately. And he filed the writ petition on 2nd of February. By then, the writ petition had already become impervious because there is no grievance could have been there in the writ petition. And that the only grievance he has made is the other writ petition in this 5.3. And we have specifically pleaded in the counter that the grievance having not been there because the NPA was already been withdrawn.
Yes, what do you say, brother?
My lord, same statement of account. Kindly see. Same statement of account.
Yes.
The condition is, before that, if your lordship see what RBI says, precisely how to deal in account as NPA.
Yeah. Yes. For 3 months, three consecutive months, he has not paid.
No. In the CC account, he has paid the interest, but he has not paid the interest toward the entire liability. So RBI says in CC account, my lord, if he has not paid the entire liability of interest liability, then it will be treated as out of order. It is not like the term loan account. So that is why we have taken the RBI circular, my lord. If your lordship will come to writ petition 57, my lord, in his writ petition. So your lordship will come, I will read the entire how the CC facilities will be termed as NPA. An account should be, your lordship got it 57, that is
2.1.2, Roman 2.
Roman 2. The account claims remains out of order for a period more than 90 days in respect of overdraft or cash credit CC, my lord. Then there is a clarification too in the last, my lord, in at the rate, any amount due to the bank under credit facility, if not paid by the due date fixed by the bank, become overdue. Then account should be treated as out of order if the outstanding balance remains continuously in excess of the sanction limit or drawing power. It is one part. In excess where the outstanding balance.
In cases
where the outstanding balance in the principal operating account is less than the sanction limit or drawing power, but there are no credit continuously for 90 days, or credits are not enough to cover the interest debited during the same period, these accounts should be treated. What he said, he has deposited the interest but not the entire liability, interest liability in the 90 days. So that it covers. Credits are not enough to cover the interest debited during the same period. These accounts should be treated as out of order. If it is out of order, then it has to be treated as NPA. So accordingly, we have declared it on 30th 12 2024, and next day he has
declared what? Out of order, or you declare
out of order? Once it is out of order, in the system will say it is NPA in CC account. So 30th 12 2024 declared, and 31st system said that it is NPA, and next day he deposited 50 lakhs million. So that is why then account is standard. So it is only a academic milord, because he said nowhere it has been informed that either the civil we have informed, because he has paid the amount. So that writ petition, in my view, milord, but my senior has already submitted. So it is only academical now. Once it is standard on the next day, it cannot be treated as nowhere we have stated, nothing it is informed. Because the system has done it 30/12 and 31st he has paid. He is aware. So immediately he has paid. When he has paid, now the NPA tag is not there, milord.
Pleadings, your lordship will find para 7, 10 and 11 will counter, milords. So, and this has not been considered by the honorable signatures.
Now, what is the order made by the learned single judge operative portion?
Yes, your lordship kindly see, honorable single judge has framed 3 issues, which your lordship will find from the impugned judgment, milords, at page 91. Page 91.
Lordship may refer 966 of 2025, Lordship.
It's a common judgment.
Second, common judgment.
Yes, common judgment. Yes. Common judgment. Starts from page 81 in the first writ petition, 966. Yes.
The allegation regarding the capitalization of penal literacy unfounded during the period of
let me place 3 questions, milords. Whether the reduction of the sanctioned cash credit limit by the respondent bank from 14 crores to 6 crores, as communicated on 13/11/24 was is
para 7.
Sorry, Milots, para 7, yes. Para 7.
That is 93.
Para 7.
WA?
Writ appeal 966 of 25.
93.
It starts from page 81 and internal page 91. Yes. Issue number 2, Milots. Whether the classification of petition of cash credit account as a non-performing asset on 31/12/24 was in compliance with applicable guidelines issued by the Reserve Bank of India and supported by relevant facts. 3. Whether the respondent bank levied and capitalized penal interest in violation of judicial decisions and regulatory directions, and if so, whether such action is sustainable. Now, these 3 issues, Milots. First issue is covered by Milots, my latest communication, which your Lordship have referred to, asking me a friend to see that. This is already restored, Milots. 14 lakhs is now made available in full swing, Milots. 14 crores, so sorry. 14 full available, Milots, and subject to Milots is complying to the renewal conditions, which every borrower has legal documentation, legal compliance, he has to make. That your Lordship, he has to do that. 1. So this Milots stands fulfilled. We are not going to so much of controversy, but there is no need also.
Now, we are now about the amount of that capitalization.
That I'm coming. That I'm coming. For a moment, I understand. Yeah. Second is NPA issue, Milots. NPA, as I said,
next day he made the payment and determined sacrifice.
So no cause of action survives. It has become infructuous rather. So it goes. Then third issue. Third issue, Milots, is capitalization of penal interest. Capitalization of penal interest. So ratio is concerned, Milots. I am bound to abide by the Supreme Court decision, Milots. Only thing is that so for a pleadings available with the writ petition which my friend has filed, Milots, that only takes care of the 8, 12, sorry.
No, it should be other period also. You might have drafted.
I never.
Suppose if you have done it for the earlier period, you want to retain that money.
I will continuing to do as on today.
As your
despite having the judgment, despite having the constitutional bench judgment cited.
Do I quarrel?
No, that's why I filed a contempt also. How can you charge the capital, the penal interest, despite having the judgment and the stay of the order?
Now, what has happened, in fact, all confusion started. Somehow RBI has belatedly issued the circular. But we have not charged. That is our stand for the period, because the judgment of the Honorable Single Judge, which is imputed for Lordship, that says you have to comply as per the RBI circular. Because RBI circular we have complied with, but that doesn't satisfy my friend's need because
you have to make the
exactly the RBI circular takes you as a part of the period. If that is why your Lordship rightly said, let him make a representation.
For earlier period.
Yes, for earlier period.
What is the amount according to you roughly paid by way of?
Roughly till last year, my lord, 1.26 crore.
1.22.
Till today they are filing.
Your
calculation.
Calculation, yes.
He may not be right. According to you. Then you have all the documents.
According to nothing. According to him, Millers only. I'm sorry to say. According to him.
No. Well, not a single judge.
My Lordship, kindly see. Just I'm so sorry. Your Lordship, kindly see paragraph page in the judgment I'm reading, Millers. In the judgment, your Lordship, kindly submission on behalf of petitioner.
Brother, that the out of order issue, NPA issue, perhaps you don't have a case.
I'll show to your Lordship that after.
Sure that. That's the only point now.
Yes.
5 minutes we are giving you.
Yes.
Within 5 minutes you have to complete your answer.
Yes, my lord. Lordship, may kindly see the first writ petition.
Yeah.
31627. Page 29, Annexure 7.
Yeah.
I have filed statement of account from 1st April 2022 to 10th December 2024.
Yeah.
Page 29, Annexure 7. Well, the overdrawn limit has to access to the limit, the drawing amount access to the limit has to continue for 90 days. Not even a single occasion. Apart from 30th September 2024, where it exceeded 1st October, I paid 2 crore. Lordship may kindly see the statement which showed by the bank. They downloaded from 2nd October to show that I have not paid. Whereas 1st October, not always the accounts are from the beginning of the month to end of the month. See the
1st of October to 31st.
But they downloaded from 2nd October to show that I have not paid. Whereas on 1st October, I paid 22 crore. The statement they showed to your Lordship in the appeal starts from 2nd of October, telling me that you have not paid. But 1st October, I paid 2 crore. 30th September, it exceeded limit. That is where the same circular also says, RBI, that Temporary discrepancies like exceeding the limit for a small period cannot be a trigger point to classify an account as NPA.
We have not done.
Your Lordship, may kindly see every time.
Sir, please.
Sorry.
So for 2 years statement of account I have filed, not even a single occasion they could point out to the Honorable Single Judge that here he continued for exceeding the limit for 90 days. Here the cash flow is not there. But it is interlinked. If there is no cash flow, the account will be overdrawn. Because if I continue to debit the account every time and the credit is not coming.
On that, what's the learned single judge said?
Lord, paragraph 14, if your Lordship may kindly see of the judgment, impugned judgment.
In terms of clause 2.1.2.
My Lord, in terms of clause 2.1.2 of the Reserve Bank of India's Master Circular Income Recognition, Asset Classification, Provisioning of other related matters dated 1st July 2009, the NPA is a loan or an advance where the account remains out of order for a period of more than 90 days in respect of an overdraft or cash credit account. An account is treated as out of order if the outstanding balance remains continuously in excess to the sanction limit or drawing power. Even where the outstanding balance is within the sanction limit or drawing power, the account shall be treated as out of order if there are no credits continuously for 90 days or if the credits are not sufficient to cover the interest debited during the same period. Next paragraph, further paragraph is important, my Lord. These conditions are cumulative in nature and must be objectively established based on verifiable data. The petitioner, relying on account statements, has demonstrated that substantial credits were made into the account within the 90 days period preceding to the date of classification. The account was not continuously overdrawn during this period, except for a single instance of 30th September 2024, which was promptly regularized on the following day. Moreover, as on 30th December 2024, the date on which the account was classified as NPA, the outstanding liability stood within the sanction limit of 14 crores of rupees. The respondent bank, on the other hand, has not produced cogent material to revert these facts. Its pleading reveals inconsistency, as in its affidavit dated 16/1/2025, it concedes that the account was indirectly saving itself from the being declared as NPA, while in a subsequent affidavit dated 5/2/2025, it asserts that the account had already been classified as NPA. Such contradictions expose the lack of procedural transparency and cast serious doubt on the legitimacy of the classification. Because when they filed the affidavit, counter affidavit in the first petition, Miller, that was on 15th of January 2025. If my account was classified as NPA on the 30th December 2024, they could have stated in the counter affidavit. The counter affidavit was after the account was classified. Entire counter affidavit is silent on the date of classification of NPA. When I filed an IA,
no place for interference. All reasoning is given. It may not be to your satisfaction. Learned single judge has meticulously considered the points which he had canvassed before him.
NPA on NPA.
NPA also.
On NPA.
In NPA also, though you are saying that it is machine generated, if you should have done something to ensure that it does not happen. Because after the Lotus Group of Hotels versus the Gujarat Finance Corporation, these financial agencies also operate as Article 12 entity. Your bank is a statutory established entity. Very State Bank of India Act.
Because I am showing to the very document which my friends have filed, page 29.
Your learned single judge has considered all aspects.
No, his own document. My lords may kindly see page 30, Millers, page 30. Sorry, I'm so sorry, page 31.
No.
Page 31. My lords may kindly see the balance amount, how he exceeded time. He says once.
Anyway, that prayer now, that direction itself has spent now. It has spent itself because very next day on payment of money, you have restored the status.
Absolutely correct.
Therefore, that goes now. But we will not interfere because you were not supposed to put him to the trouble.
We have never, Millers. We have never. We can never be lost.
That impression.
Yes, had that been so, may I tell my lords, Millers,
yes.
Had that been so, Millers, once we have already intimated that we will be phasing out to a limit, Millers, of 14, then to 9, then to 6, Millers.
No, even otherwise also. Now your challenge bends into insignificance because it was stand in the memo. this memo
Minors.
will take away your attack on the impugned orders.
Because
They will not go against him. They go in his favor.
But he is happy now. He has shown in the next.
But no, he is against setting aside the judgments, which he has earned after a lot of fighting.
Lord, one
Millards, your
judgment,
Lordship,
Lordship, may kindly see how banks should be treated, why it is established. Your Lordship's judgment, my Lord. I've had one judgment, though it's a single judgment.
No, let me complete.
Nitesh is state.
My Lord, this is Legend Property versus the State Bank of India. This paragraph, page 8, paragraph C. No, once you commit, my Lord, you can't bring on road. Suddenly. Secondly, my Lord, on the temporary discrepancies, the Honorable Allahabad High Court, the division bench has held clearly that on temporary discrepancies.
Why you did not produce the account statement for entire calendar month? Why it began from 2nd of the month? We should have begun with first day of the month.
Because first I paid
on the first day, if you do it, he will be doing, there will be compliance.
Your Lordship, may kindly see the repetition and the annexed documents, my Lords. He has submitted a part of the document. I have to respond, my Lords.
No, but account statement, you have to start it with first of even accountancy.
My Lords.
Accountancy, which any ordinary commerce student will learn.
My Lords.
Accountancy, normatively, unless the law otherwise provides for, it should be from first day of the month to the last day.
Last April to 31st March.
That is the assessment year, this accounting year, this is the year. Monthly statements. Suppose if I ask my banker, give me the monthly statements in the breakup, he will get from first of the calendar month to the last day of the said calendar month.
That is based on equation, my Lords. Because whatever we ask, my Lord, they give, my Lords. That is always there, my Lords.
That's what, but when you had filed the account statement for the month, that should have been with the first day.
My Lords.
That's
what I am submitting.
What
I am submitting, my Lords. The three issues which I read over to your Lordship, my Lords. Your Lordship, may kindly see how the Honorable Singh is.
No, yes, that with
no finding.
What?
On
why the question should be answered against the bank in favor of the borrower? They have given even otherwise. No, why are you calling us to examine all these things when your stand is this?
Yes. Yeah, what I am saying, so far as the reduction of cash limit is concerned, your Lordship will find there is no discussion, nothing, no deliberation.
Even otherwise, now it pales in insignificance because of your stand. You have restored.
I have restored, my Lords.
That's what.
And he is happy, my Lords. Your Lordship kindly see the letter.
There is the requirement of upsetting the judgment.
No, we are not upsetting
the contempt court.
We are not upsetting. How can we upset, my Lords?
No, upsetting the judgment means setting aside the judgment. I am using some different English term. That's all.
Now only, my Lords, grievance is redressed. That is what. I think. Let me precisely recapitulate my stand, my Lords. So far as 14 crores to 6 crores is concerned, my Lords.
You have said that we remember everything. We don't need any repetition.
NPA, my Lords, it has already become inferior to record, my Lords, on record. Because already on the very next day it has been withdrawn. So no NPA.
What happened to the repayment component?
And so far as the capitalization of interest is concerned, my Lords, as your Lordship said, my Lords, rightly let him give representation.
Why represent? There is an order.
Sorry?
There is an order now. You have to do it. Why representation? All accounts are with you. All books of accounts are with you.
Period is.
Period only.
You should work out for which you have imposed a penal interest. That you have to work out from the record. He need not give anything. You have to give the money back to his pocket. You have to put the money into pocket.
We'll verify.
Nothing. You verify and do it. We are not inclined to broadly agreeing with the reasoning of the learned single judge. First off. The other reason as to why we don't grant indulgence in these offences, the memo dated 9/2/2026 filed by the Bank's Council, which reads as under. First off, the memo is accompanied by two documents, one dated 1/2/2026, another dated 2/2/26, which read as under. First off, in view of the above, appeals being devoid of merit and not warranting re-examination or disposed of as
Millard subject to the memo.
Nothing. We have taken the money. of the people. Yeah.
Item 19.
Yeah.
Is people resolved
Yeah.
that the bank had appeared so moto on the last occasion, and pursuant to your lordship's order, they were served with the copies of the repetition, etc. Just
They're not present.
they're not present, but what has happened, I'll just show to your lordship.
Now, how it will help you in the absence of the other side showing all the things to us?
Your lordship may kindly see the last order, and your lordship may see today's affidavit, which I have filed.
Served on 3 working days.
Affidavit I've given, after your lordship had passed that order, kindly see what they are trying to do, my lords. Yeah, this is a case where, my lords, they accepted my restructuring proposal, acted upon it, appropriated the money, but went on to issue a 13-4 notice. And now they give a email. Kindly see page 7 of that affidavit.
Restructuring plan remains valid, subsisting. There has been default or breach on the part of the petitioner in complying with the terms and conditions thereof. Despite the same. Frustrating without it.
Can this be accepted, my lords? And I had shown to your lordship on the last occasion.
You are the borrower.
I am the borrower. I had shown to your lordship that my restructuring plan was accepted by them.
Then we'll come on tomorrow. Let him
page
come tomorrow.
I be protected, my lords, because there is no interim order passed by your lordship. Your lordship
tomorrow
had said, your lordship, the matter appeared before your lordship on the last occasion.
Yeah.
On
all this matter tomorrow.
On the 3rd of February, and the email was
tomorrow. Yes, next. No, make it daily list. Daily list, every day list. Next.
Weekly list item 1.
I mean, pardon to make a mention, my lord.
Yeah.
Item 45 weekly list, your lordship, covered by your lordship's order, my lord.
I think I mean permitted to examine the matter because I'm not ready with the brief. Yes, sir. Lord's not taking serious.
We want to see whether it is or not.
Yeah.
If we are convinced, we will not give you time. Prima facie, if we are convinced, we will not give any time at all. This is common order.
Common order, my lord.
Your case was also along with that.
My lord.
What is that?
Allow with that.
Yes. So you want to verify? You go and verify after passing the order.
Yes.
Annexure 1, you do not order, you not kindly see.
Annexure 1. 45, no?
Item 45.
Your petition was also there along with them.
My lord. Page 19, my lord. Page 19 of the writ appeal, my lord.
190.
Was your
in case of Gopinath Sahu, your lordship decided that issue in WA number 141.
so yours is Tapan Kumar Sahu?
Tapan Kumar, present to
Item 53. This is only coordinate with judgment on the single judge has passed the order.
So Gopinath, your lordship have decided upon same order.
Same. Oh, yes.
Item 53. Based on the coordinate division bench of this honorable court's order, the honorable single judge and party order that has been challenged by for writ appeal minor after more than 1 year and 6 months. So we will take up tomorrow minor today.
Let us see today go through it. This is next matter. One by one.
Weekly list item 1.
Any covered matters are there? If there are any covered matters, we will pass some order. Yes, start. Weekly list.
Weekly list item 1.
Yeah.
Just now I have received the copy, my lord.
Yeah.
Next week, next week.
Next week.
I am for the appearance.
Next. That's the request now. Yes, next.
Item 2.
Right.
Yes, sister.
Yes, my lord. Private opposite party. Respondent number 4 and 5. Well, the file read.
You are for the appellant. Are you for the appellant?
You are for the appellant.
I am for the appellant.
Yes.
My lord. Respondent number 4 and 5 filed a petition under section 37(1) for correction of pata. Well, that was recorded in our name, that deleting their name and to prayer for recording the name of the DT. Well, that is allowed without giving any opportunity to me. I have not been heard. Well, I will go through the order, but that order was challenged in the writ petition. Writ petition was allowed on the ground that endowment commissioner has not been noticed, so that is not valid. Well, I am going to the order annexure 4, the revisional order. Page 29, your lordship, kindly see. Mine.
Annexure 4. These are not visible.
Order dated 22/3/2018.
22 or 27?
27/3.
27.
Sorry, 27/3/2018. Let it fast para, your lordship, kindly see. This case was taken up on 6/2/2018. Advocate for both the petitioner and opposite party number 2, 3 and
10 appear.
My lord.
1, 4, 2, 9 did not.
2, 3 and 10 appear.
That means 1. That means logically it means 1, 4
to 9
did not appear.
Did not appear.
Who were you?
Well, we are the present petitioner, my lord.
You are.
My lord.
You all.
No, not all.
Then what do you have to say? Which one? You were opposite party number?
2, 3 and 10. My lord, specifically I will say, my lord, page 21, your lordship. That revision of petition.
We are asking a question.
My lord.
2, 3, 10 were present.
Not present.
Not present.
No. Only appeared, but on the date of argument, they have not given the opportunity.
They appeared on 6/2.
Petition has not been, my lord, made. My lord, opportunity, no written statement, no deliberation, nothing. Order has been passed. My specific stand, this is a part of the person.
Taken 6/2.
On that day, not on 23rd saying. Who appears for the other side?
Other side, my lord, private parties are there, claiming to be the trust for respondent number 4 and 5.
Notice has not gone to them.
No.
Issue emergent notice. But the matter lies in an error from first. Post immediately.
Lordship, all the matter same, only khata number different. Therefore,
in all these matters. Okay. Next.
Item 3.
Yes.
The judgment of the learned single judge at annexure 20 has been challenged in this intra-court appeal.
What is the subject matter?
The subject matter is that a assistant professor was directed by the vice chancellor to take charge of the department of the computer application at the HOD of the computer application, along with other employees also, so far as the other departments are concerned. If a order was passed by the Vice Chancellor and she was directed to take charge within 7 days, but she did not take charge and she asked for certain documents from the registry, and that document though was not relevant, but she asked for the document on 25/7. I have prepared a date circular on 25/7/2022, 8/8/2022, and thereafter the university reply on 19/8/2022 about asking for that document, Miller, at answer 3 at page 49. And in spite of that reply, Miller, she did not take charge. Thereafter, and she went on asking some absurd questions by issuing the letter on 26/10/2000.
Who appears for the opponent?
I'm for the writ petitioner respondent, against whom the order of punishment of compulsory retirement has been passed. Against the memorandum charges, the charges leveled against the writ petitioner was that I did not.
The first time it is coming.
Yeah. Not first time. Please. No, after not. I have applied on caveat, my lord.
You enter caveat.
Yes, ma'am.
Yes.
So therefore, the university asked him to show cause why she is not taking the charge. That is on that the lordship can see the on 25th, 21/10/2022 at answer at page 56. With reference over the charge of HOD computer application, via memo number so and so, but it found that you have not taken over the charge of HOD computer application in spite of several requests, via letter number so and so, dated 19/8/2022, and a reminder letter dated so and so. In view of the above, you are called upon to explain in writing within 7 days of receipt of this application or explanation of this explanation, failing which action as deemed fit shall be taken against you. But this is the letter was issued. Thereafter, your lordship can see he replied to that on 26/10/2020.
So, brother, you were asked to take charge of a department.
Yes, ma'am.
You said you give me 1 week to take a decision, think back and think and come back. Then they gave 1 week. Then after 1 week, you said, instead of taking the charge, you asked the university vice chancellor to take action against the registrar and to warn him not to issue such letters at all. The conduct of your client.
My lord, what has happened is
how to run the university.
My lord, what has happened is that there are only limited faculties available in the Department of Computer Application. What they do is that in every 3 years, they interchange with the handing over the charges among the 3 to 4 faculties. Earlier also, I have accepted the charge of HOD. I was running the department. In this present term, when I was issued with a letter to take over the charge, I requested the registrar as well as the VC, the person who was presently incumbent at that particular firm, to regularize those documents and thereafter to hand over the registrars and all the documents. Thereafter, I will take over the charge. That part they have not considered it. Instead,
you take charge, then let them arrange for the other enlisting of items which you have to take. First, sit as the head of the department.
This goes concurrently, my lord. Along the person from whom I have to take over the charge, that person will provide me with all the updated registers and all the documents.
Correct. Whatever whether that person handing over committee is there or not.
That the handing over committee is there.
Yes, you form a committee.
You will also can see what he has or she has done. The conduct of this employee. She did not take charge. He made aspersion against the vice chancellor, against the registrar,
everybody, and thereafter ask the question, Your Lordship kindly see. And the Board of Management took the decision that his conduct is simply not acceptable. So therefore, their charge was framed against her. Your Lordship kindly see the 2610.
Instead, what we suggest is, let her accept the charge, form a committee, hand over the charge, and she will accept the charge. Leave your charge, all other charge, we should withdraw all allegations made against the party.
I'm out of service. They have compulsory retired me. Kindly look at the page 27 of the writ petition.
Anyway,
the article of charges. The article of charges states that Dr. Sasmita Kumari Padi such and such, with the approval of the competent authority by order number such and such, was appointed as HOD in the Department of Computer Application with effect from 1st of August 2022 with a tenure of posting of 3 years. Also, it was directed thereunder to take over or hand over the charge by 37th July 2022. Dr. Padi neither complied the office order or number such and such, not took over the charge of the HOD computer application. That is the only allegation. Charges.
See, now these things have happened. There are formats of such judgments in law relating to education by Chawla. There are such judgments. Instead of doing all this circus, you take her back, let her accept the charge of that HOD charge and put the things to rest. You consult your, otherwise we are agreeable with the reasoning of the learned single.
That is also the direction of the Hon'Ble Single Judge, my lord. Page 55 of the
Your Lordship has said something, Your Lordship put it on. Next week, any date. I'll take instruction.
Heard learned counsel appearing for the appellant university and learned counsel appearing for the respondent from KVA. First one, certain discussion took place as to how the list can be put to rest amicably, and in that connection, learned panel counsel appearing for the university wants to have confer with the clients and come back to first for this matter on 26 we said there were 3 matters, no? Two matters. Yes, for this matter also.
My lord, I have some personal difficulty on 26th.
When do you want?
23rd February.
23rd February?
Yes.
23rd February. You wanted 1 week. Yes, if you wanted 1 week only. You said 1 week only.
3rd February, I will do.
Your difficulty. Choose which date is agreeable to both of you.
On 27th.
27th.
The difficulty is that my marriage is on that.
You are not invited us at all. We don't believe in that.
For that reason.
We'll call him
on 24th.
23rd.
Let him enjoy.
Then on March.
Yes.
Second week of March.
On
9th of March.
9th we'll have this. 9th of March. Wish you a very happy marriage anniversary. Sorry, celebration. Not anniversary. Celebration.
Thank you, madam.
Item 4.
Yes.
Your Lordship, seeking for the short adjournment.
You need short time. We'll give you long time. Or in the last week of March at the request of.
Item 5.
Arises out of a matter relating to Orissa consolidation of holding and prevention of fragmentation of land and rules. My lord, opposite party in the writ petition is the appellant before my lord. Writ petition having been allowed, this appeal is being filed.
What the learned single judge say?
He relying on a decision, of the Honorable High Court, our High Court, passed the judgment, which is against the norm of the statute according to my submission.
Consolidation case is questionable.
My lord.
RSD number 757 dated 25.
For fragmentation of land, as the law was then, it was declared void. That order was impugned before the Honorable Single Judge. Now an amendment has been effected in the statute. Relying
Is it
that.
a retrospective statute?
No. So Lordship may look at the statute first, then I shall argue.
Yeah, that. Statute as it existed in July 2010.
My Lord. Chapter 5 of the Odisha Consolidation of Holding and Prevention of
Can you briefly tell what is meant by this law is not there in our state? From
that chapter was itself was withdrawn by the recent amendment in the year 2023.
No, what is the idea of the consolidation of lands?
My Lord, consolidation of land means scattered lands.
Prevent fragmentation.
To make it compact, this act has been enforced in Odisha.
All pieces of lands are brought together under one survey.
That's a long-term scheme. Stages by stages it operates. Lordship may look at old law, chapter 5.
Please read.
Chapter 5 is relating to prevention of fragmentation. Once Choco is carved out under the act, there is a not fragmented.
Once
Choco is carved out,
okay.
Amalgamated.
Okay.
Law is enacted not to fragment it. That is chapter 5 of the act.
Perhaps agrarian policy.
Yes.
Agricultural policy.
Now this provision chapter has been already withdrawn.
It's
Deleted from the statute by inserting a new section. So may I take my law to old law then?
What you have said it now?
I am saying about the old law.
Yes.
New act, it is 36A. Lordship may first look at 36A.
Yeah.
New act.
36A is not for revision.
Validation of transactions.
Validation of transactions. That means transactions which have already taken place.
That has been validated by this act amendment in the year 2023.
Transaction means sale or fructuary mark is lease.
May I read my permitted? 36A. Any transfer or partition, validation of transactions. Any transfer or partition of agricultural land in a locality creating fragmentation made under the Principal Act before commencement of the Odisha Consolidation of Holding and Prevention of Fragment of Land Amendment Act 2020 shall be treated as valid. Then the proviso, Lordship may look up note of, provided that cases where any eviction has been made by the collector under subsection 2 of section...
They shall not be reopened.
Shall be reopened. Now, the Honorable Single Judge, this eviction has been interpreted as physical eviction.
Apex Court said like that.
My Lord, physical eviction must be flow from the statute. There was no statute provision for eviction so far as section 35 of the old act is concerned. Therefore, my Lord may take note of that book. That the provision is there, chapter 7, chapter 5. Chapter 5, that book they have printed it.
Yes. In the
Does it got it?
No.
Chapter 5, page...
Is number?
Page 60. My book is your Lordship's book or not? No, other book.
No, that
Not.
Old Act, chapter 5.
Old Act, chapter 5.
Section 34.
Please read.
33, application of this chapter. That is not necessary. Prevention of fragmentation, how it is fragmented.
Yeah.
Then your Lordship may look at section 35. Consequence of transfer of partition contrary to the provision of section 34(1), a transfer of partition in contravention of the provision of section 34 shall be void. Then subsection 2. Lordship got it?
No.
A person occupying or in possession of any land by virtue of a transfer or partition which is void under the provision of this act may summarily evicted by the collector. Now that proviso
is not here.
Here. Now this has been.
That means eviction means eviction by the summary procedure.
Yes. That is how a person will be evicted. There is absolutely no law in the statute. Here in my case, collector has directed the Tahsildar, but however the single judge relying on the another decision of this honorable court says that since the physical eviction has not been made, he is not evicted, so the transfer is valid. Lordship may look at that judgment. The honorable single judge relied on a judgment of this court.
Venudhar's fine.
Venudhar.
Venudhar's fine.
Paragraph, your Lordship may straight away look at paragraph 12. The honorable judge has taken note of para 11, the old provision, then section paragraph 12. May I permitted to read that manner?
Yes.
A careful reading of the Amendment Act 2023 contains 3 sections to be revealed that legislature has omitted such provision as to the bar and ancillary provision of section 34 and 35 as those were in the Orissa Consolidation of so and so Act. Thus, the fragmentation is no more a contravention to invite invalidity to the transaction and face the eviction from the land in question. The legislature's intention thus is clear that prevention of fragmentation is now not at all the focus. It is therefore that the partition of agricultural land.
The provision of section 36A has been introduced in
the statute. Sorry, my lord.
That all such transfers
of partition or agricultural land in a locality creating fragmentation under the existing law prior to amendment would be treated valid. Only the saving is to the closing cases where the eviction has been made by the...
We have made the case for issuance of notice.
My lord.
Issue emergent notice. They will sought for stay of the impugned order.
My lord.
Any application is there?
Your Lordship says so far no third party interest may be created.
Application.
No third party interest may be created.
Heard Lieutenant Counsel appearing, signs of appearing for the appellant. First off, a case is brought out for issuance of emergent notice to the other side. And also for favorable consideration of his application in IA number, so and so supported by the affidavit. First off, since matter requires deeper examination, the reprieve needs to be granted to the appellant in a particular way. First off, in the fitness of thing, we are of the considered opinion that the subject land shall not be alienated or encumbered by the opponent, by the respondents till the next date of it. First off, if this order is made ex parte, it is open to the respondents to show that this order needs to be varied or vacated.
No notice to opposite respondent number 5 state.
Yeah, they should also appear.
I shall take notice.
See, right, so the same appears for the way appears for P number 5.
Item 6.
The order at page 31, Annex 5 is the order passed by the Honorable Single Judge. Well, where, my lord, the repetition of the petitioner has not been entertained on the ground that a criminal case is.
What was the prayer before
the prayer, my lord? Without following the process of law, the account of the petitioner has been freezed by the bank. The Lordship will get it. Lordship may turn to page Annexure 2, page 20, my lord.
What was the complaint against you?
Complaint against my lord, it was not within my knowledge. Nothing was communicated to me. Now, my lord, the complaint against me that the opposite party, the respondent number 4 has lodged an FIR that he had given me certain money to supply rice and I did not supply. That is the allegation.
Where is that?
That is
FIR Annexure 3.
3, my lord.
Let's see.
Annex 3. Annex 6, my lord. Annex 6, it has been registered and your lord will get it. Annex 6, page 36. It was registered on 28th of March 2025.
Where is the gist of that?
Gist of
content.
That is
Page 47, next page.
There are 12.
Yes. That is so far E, page 11, I have given that.
Yes, suppose there is a transaction. And if the transaction is entered into with the intent to defraud,
yes, ma'am.
That is a mischief.
That is
Section
mischief,
4, 20, 21, 22,
Yes,
23,
yes.
24,
For
25.
a moment, lordship may turn to page 20, madam. Because my lord, he is an outsider. The petitioner is an outsider. He is a man of West Bank. The petition of the respondent number 4, who belongs to the state of Orissa. Intentionally he has lost the affair because the petitioner had given him money. I have given all the transaction.
Only 67,000 you have paid.
Yes,
having taken.
No, I have not. That amount I have not paid in respect of the money I have received. That is the money I have given to him. He is to supply the rice. When he did not supply rice, I informed him and I asked him, in order to avoid that payment, the FIR has been lost. And your lordship, how they have managed at the police level, your lordship will get.
You take notice. We will not
The one thing your lordship may have, I will take notice.
You take a much notice.
My lord, that has been there.
I am is come to the notice for 3. Emergent notice to 1, 2, and 4. Returnable in 2 weeks.
Item 7.
Same.
All along with each other. Next.
Item 8.
Your order of the Honorable Singhal is under challenge at an extra 2.
Yeah.
Lordship, from the relevant portion, page 35.
Fine.
Here, initial the it was disposed of as
order on IA.
No. Final order disposed of and withdrawn. Then the petitioners file an application to recall the order and pass on merit. So this order was passed, recalling that order. This order was passed.
No, wait. That order is recalled.
Yes, come to para 3. Para 4. Para 3, this application seeking modification of the order so and so. It is content that instead of dismissing the writ petition on the ground of being withdrawn, the writ petition being disposed on merit. Then this order has been passed. Without entertaining, the matter was dismissed. Here, cross of the matter, my lord. I filed the writ petition seeking for a direction to the director, elementary education, to cause inquiry so far educational qualification of OP number 5 is concerned. Who is serving
when he was appointed, OP number 5.
My lord, your SIP annexure 4 come to 8.
I will not say anything. We are asking the date.
Date, my lord.
When he was appointed. And how you are interested in that?
We are the villagers of that village.
You file PIL, the order is correct.
Yours may issue writ of co-warrant also. As yours, for a moment, yours can come to an extra 4.
You now show when he was appointed for a writ of Govindra versus State of University of Mysore says the full particulars have to be furnished by the person who seeks writ of co-warrant. 1955-56
Yes.
Supreme Court.
party. Yeah, silent.
No, even your appeal doesn't say so.
That's your
Where have you pleaded? You're just asking us to, so
No,
you may be doing
that-
the other extortion business. Therefore, we are asking him, when was he appointed?
That part is silent. I have to obtain this stuff from them.
No, not question of instruction. Where have you stated in the petition, in your petition, that there is one judgment, GK Mr. Pranav, which is that judgment? GK GK Govinda Rao versus Mysore University. Can you take a Google of that judgment? Can anybody take out youngsters?
Just to CORAM.
Yeah.
Yes.
That's what. Which is that judgment? University of Mysore versus CD Govindrao. CD Govindrao. It's 65 SC 491.
Yes, you know. 1963.
But where is the compliance with this required?
No.
Nothing.
No mention it.
Just you want the inquiry should be held to satisfy.
Inquiry already held.
Why it should be held at all at your instance? If they want to hold it suo motu, I can understand. AR 65 SC 491. 490. Yeah. It's a good judgment. It's a fundamental judgment on law of writ of Guarantor. One of the best judgments. Those days, the little development also has taken place thereafter.
BR Kapur.
BR. You are right.
2001.
From Madras cities, it was from state of Tamil Nadu.
Yes, Tamil Nadu.
Tamil Nadu.
Yes.
Where they were continuing particular one-day break, their ministers were continuing that way. Nothing.
That part is concerned, my lord.
There is nothing.
But you have a glance on Annexure 4 only.
Annexure 4. No, we are asking you, what's your locus? Who are you?
We are the villagers in
No, that will not give you. That will not give you the locus. Locus coupled with locum, both are required.
Yes, sir.
We are only blindly going locus and locus. No. Locus and locum, both are required.
Next week, next week.
What?
I'll either amend the writ petition, writ appeal, or I'll obtain instructions.
All of the two. Matter having been argued for some time, we are not yet convinced that matter is meritorious. First off, learned counsel appearing for the appellant wants to make some more endeavors. First off, call week after next, before this bench.
Item 9.
Yes, Mr. Mishra.
Third point involved here is
yes,
the notice inviting applications
or
Anganwadi worker, if that has not been complied with and the mandatory requirement not followed, and the application was accordingly rejected by the committee. The chairman
headed by the collector,
sub-collector rejected it. And the second person in line, 1, 2, 3, 4 other, one didn't comply.
Next in line will.
Next in line has been selected. That was challenged in appeal. Reason being
by the first
person was not selected.
Who was not selected.
Their contention is that the documents which is required to be filed were filed at the time of scrutiny.
What is that document?
Document is their eligibility with regard to the passing of plus 2 examination, which was the document justifying through result and the mark sheet was not filed along with the form which is mandatorily required.
Where is Justice Gopal Gowda's judgment? Which is that judgment? Do you have a copy of that judgment? We
Last week, yes. Only last date.
Last week we were entered one judgment.
Last week.
Also last week, my lord, that is on.
Where they said all documents should be produced.
Yes.
That judgment.
Item 2 of that
take notice.
weekly list.
Other side is served.
I'll take note.
Issue emergent notice. Since the counsel for the appellant heard that a period was right, so precisely the service side in coordinate decision is so Sakshi versus right. So another day we passed it. The local certificate need not be produced, but other certificates have to be produced.
Last week's
Huh?
lordship's weekly list, my lord, item 2, my lord.
You remember that you have to make notes of all the judgments. Yeah. Better license in narrow compass.
But I was elected and I was appointed.
Interim order you are sought for.
Right.
But you have been out of service how long? No interim order can be because you have not been issued the appointment order.
No, it isn't the appointment.
Who? How?
Because I have been selected. I was selected.
You were selected. Where is the appointment order?
Yes, if not, so can see.
But since how long you have been out of service?
Hardly 2 months, I think.
That's all. Just verify.
If you not look at the appointment letter,
Appointed partner of 5 is working in our place. He has been appointed.
He was appointed.
Yes, ma'am.
Page 31, if you not look at.
Appointed or continuing? Yes. As on this day continuing. When? After the order upset has happened, na?
After the order.
Mr. Mishra draws our attention to application in IN so it was supported by affidavit. First officials that his right was appointed on 4/11/2023, correct?
Right.
Wide order number 794, 754 or 754?
And
That's 6.
Yes.
754.
Respondent 5 continuing since 24 months.
Respondent 5 is continuing.
Yes, ma'am.
Not, that is appellant.
Sir, I was appointed after the order.
Since 2024, she has been continuing.
Yes.
Let us see. We will not do that.
The short date will be fixed so that
So application in IN so it's supported for the plea.
There is no IA, Mr. There is no IA. There is no IA also.
interim application.
No, you have not filed any interim.
Or yourself put a short date.
Show him again.
I am for 1 to 4, my lord.
Huh?
I am for the 1 to 2, 3 and 4.
You appear for R5?
5.
So it's appears for R5. Matter lies in the narrow compass, call this matter in the last one. Yes.
Item 10.
No, sir. Challenge the order of the honorable single judge may not. Directing the not to carry out the order of the collector, who is the appellate authority, not restricting and not asked to function the daily heart in our Gram Panchayat and directed the not collector to immediately not implement his order by not the other Gram Panchayat to continue with the daily market not. Here in this case not. What has happened?
Market.
Daily market blocks. Daily market blocks.
Yeah.
Respondent number 6 blocks filed a writ application before this honorable court saying that the present appellants, those who are running a hut in a different gram panchayat, that dispute between 2 different gram panchayats not. A hut is running in our gram panchayat, another hut is also running in their gram panchayat not. Daily market is same block notes and is running differently notes. The other gram panchayat notes, they objected running of the notes daily market in our gram panchayat on a particular day, that is Saturday notes. They raised a dispute and they came before this honorable court. This honorable court directed the collector to take a decision. Accordingly, notes, a committee was formed and they called us and the collector, they directed, if you say that is order under annexure 1 notes to the writ appeal, which was under challenge before the honorable single judge.
What it says?
No, he says that the
Sub-collector Kamakhya Copy number 2 in the case.
So 2 different dates were given.
Yes, but they said that on Saturday it shall run in their way the Gram Panchayat and we shall run the hard daily market on some other day.
Other than Saturday.
Other than Saturday. So we challenge that order saying that because it is 2 different Gram Panchayats, there are 4 to 5 villages dependent upon our Gram Panchayat. So it is confined to our Gram Panchayat only, whether it is Saturday or any other day, it doesn't affect the other Gram Panchayat. And we challenge that order and they also came up before this honorable court to implement the order of the collector. The honorable single judge, while allowing the writ application of the respondent number 6, directed to immediately restrict us from functioning the daily market on Saturday
and directed us to make a fresh application for conducting the daily market on some other day. That is
Who are you?
So we are the President and Secretary of the daily market of the appealant Gram Panchayat. Gotarai Gram Panchayat, there are not two Gram Panchayat, Gotarai and Bilivarai.
It's a matter of convenience.
Take emergent notice. Yes, issue emergent notice. Learned AAC is requested to accept notice for 1 to 4. Emergent notice to 5.
I will also make.
With
Why also? No, Sarpanch.
2 matters. One is
Sarpanch bill 6 minutes.
6, sir. Emergent notice to Sarpanch.
Sarpanch 6.
Another is?
Another writ of appeal, because there are 2 writ applications, Lord. So I was compelled to file 2 writ appeals against.
Which is that? Which is that?
That is
not number.
Writ appeal number. The writ appeal nowadays.
44895.
Yes, Lord.
That in die.
In that, in matter 1 to 6, 70 is Sarpanch. Emergent notice. Also, post immediately after service.
Item 11.
So I filed an interim application, Lord.
Consider after they got.
Then you also issue notice also there.
Okay. IA applications in IA number so and so will be considered after after the appearance of private tool. Yeah.
Item 11.
Private respondent. Yes.
Item 11.
Yes, Mr. Panda.
I am for the official respondent. It's an appeal filed by the private party who had lost his case before the only single judge. Perhaps the matter has become infructuous.
It appears that way.
It appears that way because the time period which has already
that
elapsed.
itself has expired now.
Yes.
The list in the appeal appears to have withered away because of reflux of time, stroke tenure of the popular body. In view of that, the matter is appeal is accordingly disposed of, with liberty to the appellant to seek recall of this order if what is observed above is not true. Okay.
Item 12.
Tomorrow. What's the urgency? Week after next, at the request of. Next.
Tomorrow.
Urgency.
No, tomorrow.
No, not done.
But we have many matters we have pushed.
Yes,
week after next we will have.
After next.
Item 13.
No, I have filed an IA 4540 for amendment of the prayer because wrongly the prayer portion of the read petition has been reflected in the read of it. So that is why I have filed an IA for amendment of the prayer.
Okay. No, I think on merits, what is the matter? Just
so
tell us.
The matter is like that, my lords, that the Tahsildar Jaipur, land in question has been occupied by us, my lords, for the purpose of, my lord, giving ticket to the passengers in the Jaipur bus stand, my lords.
They have occupied that.
My lords.
How was
since, my lords, they have not alerted, but we are using that land in question.
What's your right to use public property?
That's right, my lords. Admittedly, the land in question belonging to the government, my lord.
No, you have been issued eviction.
No, that the whole crux was that, my lord. In the year 2022, the Tahsildar issued a notice, my lords, to vacate the land within a period of, my lord, 3 days.
How many days you have been holding over the land now?
Which is more than 30 years, my lord.
So we'll direct you to pay every year 5,000 rupees. For using
so far in the landed single judge read petition is concerned, we have challenged the order of eviction notice, and on the ground that, my lord, they have not issued the notice in accordance with the, my lord, the provision of law under Appeal Act, my lord. And that apart also, my lords, that and thereafter, my lords, we have also applied for settlement of the land in question under section 8A of the PLA Act.
For that land itself.
For that land itself, my lord. Because, my lord, the interest, so far, my lord, the occupying land in question is that, my lord, only for the purpose of using the same, my lord, the providing the helping the passenger at all, my lord.
Next.
My lord, there is a clear observation in the paragraph 8 of the law.
Yes. Next.
That they have already handed over it to the administration. Now they are paying the appeal.
No. Anyway, even otherwise, you are not entitled to it. It's a public property. You cannot. Yes, please.
Item 14.
Yeah.
Facts of the case are like this. The petitioner is an MSME.
Make use of mic.
Petitioner is an MSME, man. Micro and small scale industry. He has worked under the opposite party corporation, Central Electronics Limited. There are some disputes.
Award was passed on which day?
16/11/2019. And the award is, apart from other, based on a admission made by the opposite party in a letter to me, confirming the outstanding.
11/11/2019. It is like a judgment on consent.
Apart
like
from other
award on consent.
Yes, that letter is annexed. That letter is undisputed. Now, the opposite party initially approached this honorable court in a writ petition challenging that award. That writ petition was dismissed. He carried it through in latest patent appeal. That was also dismissed. And thereafter, before the Honorable Supreme Court, and that has also been dismissed. Thereafter, he has filed this application under Section 34 before the Learned District Judge. Well, there, in the 34 application, he filed an application for condonation of delay.
What was that term? Delay.
Delay, my lord, of 476 days.
What is the condonable limit of delay?
90 days plus 30 days, 3 months plus 30 days.
90 days plus
90 days plus
30 days.
30
Under
days.
Section 30.
Maximum condonable limit. You take notice, emergent notice. Issue emergent notice. Yes. That is the other case now are equal to them. 72. Yes.
Item 15.
May I just pray one? In the meantime, as per the direction of the Honorable Single Judge, the arbitration, that 34 court is proceeding. 34 court on prestigious is proceeding with the matter. As per the direction of the Honorable Single Judge.
Have you filed any IA?
Yes, ma'am.
Any IA you have filed?
Yes, ma'am.
What order you want to
Stay operation of the judgment of the Honorable Single Judge.
Connect Council appealing for the cross attention of the court of application for IA number supporting by civic user. Retrieved in the first making of the come up here of the considered opinion that the matter necessary for examination and therefore a repeal needs to be accorded. First, next in the motion to application having been favored, the impugned order of the here was stated the date of hearing. It is open to the other side to show seek variation of this order or its validity. Don't do it this therefore. Okay.
Item 15.
Yes. Yes, sir.
It's a matter of compulsory retirement, Your Lordship.
Yeah.
And the matter is that he was got red-handed by the Vigilance Department. And amount of rupees 14 crores were involved in that particular vigilance proceeding, Your Lordship. That Your Lordship finds are 4.10 of the judgment. 4.1 to page 49. Your Lordship, placing reliance on the stand taken in the counter of duty in implication petition the Tribunal proceeding, where assets to the Tribunal of rupees 14 crore 88 lakhs 91,194 0.16 paisa was found disproportionate to the known source of income, the petitioner. And petitioner taking into account the guideline issued under the Annex 4. There is a guideline, Your Lordship, how the premature retirement cases are to be concerned, Your Lordship. 2019 guideline. There are two aspects, Your Lordship, in that guideline. One aspect is that a review will be taken up where they are found in the employees are found inefficient, Your Lordship.
Issue emergent notice. Any
yes. IA is there, Your Lordship. 5015 of
matter the deeper examination because of the enormity of the amount involved in gross. First one.
I've already served on the. I'm sorry.
I'm appearing for respondent number 1 on KBT Lordship.
Right.
Yes.
Already served.
We want to say anything? We want to stay there.
Your Lordship, the compulsory retirement, the order that was issued, that was in violation of the guideline that has been prescribed by the state. So on that very ground, the Honorable Single Judge was the order of compulsory retirement and gave a finding to the effect, Your Lordship.
Anyway, amount involved is 14 crore, etc.
But Your Lordship, no charge sheet has been filed in that vigilance case, Your Lordship. And in the guidelines, it very well states that if no charge sheet has been filed, the compulsory, it cannot be presumed that the delinquent employee is guilty.
No, it's not good to review. It is not guilty. It's not punitive.
It's not guilty.
It's not
punitive in nature. It is after particular years of service. They take into account your track record and decide whether you should be retained or not.
Your Lordship may kindly see the finding of the Honorable Single Judge.
Our that judgment, our judgment.
That is Jenna, Your Lordship.
Yes.
Not in the interest of public.
Yes, that way.
Not in the interest of
Your Lordship, but the review committee can only be review committee can take up the review of the employee only at the age of 50 and 55 years. But in the present case, the review committee reviewed the case of the petitioner at the age when he was 53 years old. Which, if Your Lordship see the guidelines dated 24/9/2019, it specifically states that, and the finding of the Honorable Single Judge also to that effect. From paragraph number 6 of, if Your Lordship will see, page number 62.
Yeah. Heard learned senior advocate appearing for the appellant and the learned counsel appearing for the respondent on QVA. First off, a case is made out for issuance of interim order in view of the enormity of the amount involved. First off, the payment submission of learned KVA counsel that if charge sheet is not filed within 90 days from the filing from the registration of the case, the question of any presumption being drawn against him client would not arise. First, he also tells us that the compulsory retirement can be resorted to only when employee is at the age of 50 and 55 and not in between. First, these matters require a deeper examination, keeping in view the statutory scheme. First, next for instance, in the whole circumstances, a case is made out for issuance of interim protection as for the Therefore, the application is disposed of and the impugned order is hereby stayed. Tendency of until further orders. First, post this matter in the first week of April 2026 for the case.
May I draw Your Lordship kind attention to paragraph 15 of that guideline, which says that
item 16.
Lordship, I may be on. Yes, say another matter connected with this. And another writ appeal is pending, so can be tagged, Your Lordship.
It is pending after notice.
After this, I have filed another writ because there is a 282 of.
But that notice has to be ordered, no? In that notice is ordered.
No.
Then
notice.
I'll
serve a copy.
Number.
WA number.
That matter.
282 of 2026.
Yeah.
Item 16.
16, my lord, it's a state appeal. May I prefer tomorrow, my lord?
What is the point? Just tell me. This
is regarding, this is a SOP of the central government.
so also the state government regarding vehicle location tracking devices. It has to be fixed in each and
next week. Any urgency? Next week, all right. Interest of 1 P. Yeah.
Item 17.
Yeah.
State file.
17, my lord, it's a, there is a delay of 145 days.
Yes.
The other side has entered appearance.
Yes,
Delay will cut. Appeal is filed of booking a delay of about 145 days. First of an application in IN number 1323 of
Serving the copy.
supported by an affidavit accompanies the appeal member. First, explanation is offered as to why the delay is caused. First, we find the explanation to be plausible. First, there are some arguable merit matter points in the appeal as well. First, condonation of delay will not cause any injustice to the other side. It would not add merit to the appeal. First, in the above circumstances, application having been favored, delay is controlled. But next. Let it come for admission.
No, I'm serving a copy also. They have entered appearance.
Next week, because your loss is permission, because it is a covered matter and they have already implemented the order of.
They have implemented
after order of the
I will check it in the meantime.
Next week, I will.
Next week, brother, we'll do that on 26th.
I'm serving the copy,
Yes,
because they have entered appearance.
Yeah. Next.
Item 18.
What is it?
Item 18.
I'm appearing for respondent.
Who is your friend, opponent?
Government. It's a state appeal. 29 days delay.
29 days in all these matters?
Yes, ma'am.
Same delay?
No, my lord. Somewhere it is 54, this 29, 39.
We condone delay, brother. You will issue notice all. You represent all the respondents.
No, second case, I'm not for all.
Only in which case you are appealing?
First case. Two cases. First case and second sub-item. Second case, I'm appearing for some respondents.
Some of them, not all. Issue emergent notice. Learned counsel C. So appears for respondent number. In the first case, which respondent?
I don't know, just now.
There are two respondents, Muralidhar Mudali or Vikari?
First case, I'm appearing for both.
Muralidhar Mudali.
No, both.
Both.
So appears respondent in the first case. And in the second case, who? Tell the names so that he can recall.
Vikari Sahu. Vikari Charan Sahu.
All right, let notice go. Issue emergent notice in the document. Yes.
Item 19.
Is a state appeal.
250
Here also.
days.
Yes, ma'am.
100 days we can condone. 104 days, 20 rupees per day. We have already fixed that.
My learned friend has also entered appearance. 254 days, madam.
254. Up to 30 days for appeal period.
Yes.
70 days we are giving actually for that. 60 days at least.
100 days, it is all the way.
100
now it is 254.
254 days, yes.
254 days. So if we give 90 days to you, that's 164 days you have to pay at the rate of 20 rupees. 164 into 20. 3,280 rupees you have to pay. This is a state appeal filed after proving a delay of 254 days. First of an application supported by an affidavit seeking its condonation. First of all, Mr. Mohan figures that because of the official transactions, such delays do occur, and therefore the same needs to be viewed lenient. First off, he adds that there are some arguable points in the appeal on merits, and therefore, if the appeal is dismissed only on the ground of delay, our state would be put to injustice. First off, he further adds that if the delay is condoned, no prejudice will be caused to anyone, since merits of the appeal itself will not be altered to the disadvantage of the respondent. First off, we agree with this. However, However, the condonation of appeal cannot be unconditional. First off, next paragraph. In the above circumstances, application having been favored, delay is condoned, since explanation offered is found to be plausible. First, however, that condonation is subject to appellant paying rupees 3,280
Let it be round up. Let it be round up
3,300 to no, we are following the pattern 3,280 to the respondent, and this amount is computed at the rate of 20 rupees per day's deal. First one, amount to be remitted within 2 weeks, failing which application would stand automatically dismissed on the next date of hearing, and as a consequence, appeal of the
Item 20.
Yes.
I'm challenging the order of the learned single judge on the ground that the writ petition was not maintainable, being barred by the principle of res judicata. There was an earlier order of this honorable court of the learned of a coordinate bench, where the court said grant appointment to the candidates, do not grant them seniority, otherwise it will affect persons who are not parties. He preferred a representation, and when without issuance of any notice, an order was passed in the subsequent writ petition that to grant them seniority. So therefore, my lord, is barred by the principle of res judicata.
Earlier it was said he will not be entitled.
He will not be entitled to seniority. There was a specific
issue emergent notice.
This is a delay of 89 days.
Both on main matter and application. Next.
Since my name is not appearing in the cause list, but I filed my vakalatnama.
Third, permanent counsel Shri joined so. Okay. Then we'll make it. Okay. On the short matters.
Item 21.
My lord, this appeal delay is 165 days, man.
What is the matter on merit?
Merit, my lords, taken up any other day, man.
No, you have both you have agreed that it is covered by the judgment.
My lords, that is reflected.
Several judges.
Then where is the appealability?
My lords, page 14, the order.
140.
Impugned order.
That's what. We read this. Only that thereafter, this only short order. It is agreed by learned counsel for the parties that the issue involved in the writ petition is analogous to WPC number so and so, which has been disposed of by this court.
Agreed.
Then if you have agreed, in your appeal you have taken that we did not agree with the learned single judge and still it says that we have agreed. Then no, this appeal by the state and its functionaries seeks to call in question a learned single judge's order dated 24 January 2024, whereby the respondents WPC number OAPC 141 of 2016 having been favored, the writ petition has been disposed of in terms of a cognate case in WPC number 21813 of 2022, disposed of wide order dated 6/9/2022. First off. Next paragraph. Paragraph 3 of the order reads as under. Next paragraph. Since this version of the learned single judge is not disputed in the appeal memo, comma, and the writ petition has been disposed of on the principle of parity, rightly, comma, we do not find any merits in the matter. First of all, in the above circumstances, this appeal being unworthy of merits is liable to be rejected in limine, and accordingly it is. First of all, registry to send a copy of this order to the respondent report immediately for their file of this apart, there is a long delay of
65 days.
65 days. 65 days. Okay. Next one sentence you add. Yes. Yeah.
Item 22.
No, we have many orders to sign.